And then is that, when you have that information available to you, will you go back and modify your animation, your presentation, based upon new information if it's given to you?
During trial or before trial?
Whenever. Even if before trial. If I were to come to you and say, here's, in this particular case, here's a new piece of evidence, here's a new witness statement we were unaware of, and it may impact on your animation, would you then go back and fit that into the facts that you utilized as the foundation for your animation?
Yes.
And have you done that in the generation 3, or the most recent generation of video that you created, or animation, based upon consultation with me and saying such things as, did you in fact modify the animation as we discussed matters?
Yes, the whole purpose of it is to get it as accurate as possible.
Okay. And did I then discuss with you certain testimonies in trial that led to modifications?
Yes.
For example, on some of the stills that you had gone through with the judge, was there changes in those stills based upon actual trial testimony as opposed to deposition or statement testimony?
Yes.
And did you simply take out one text and put in another?
Correct.
And object to continually.
Trying to move it along, Your Honor, to make it.
You can lead.
I understand. Were there changes that you made to the stills based upon testimony?
Yes, it's not a change in, it's more of a defining it better.
Where did you get that information from?
Consultation with you and Mr. West.
And what was discussed with you during that consultation?
What came out in court and testimony.
Okay. And based upon that consultation with either Mr. West or myself, did you make those modifications to the stills?
Yes.
As to the, we were talking about the point of, have you ever waited until the middle of trial to begin the creation process of an animation?
No, I like to begin it as soon as I can, as far ahead of trial as I can.
And in the information that you were forwarded in this case, was information from Mr. Zimmerman's various statements given to the police forwarded to you as well for your consideration?
Yes.
And did you incorporate any of that information into your animation?
Yes.
One part, go ahead.
I look at what his video testimony was and just verify that there's no conflicting or nothing that conflicts with what I used in creating the scene.
Okay. And you had all of his other statements available, the interview statements of the various law enforcement with you, available to you as well, did you not?
Correct.
And the significance, what significance did you attend to Mr. Zimmerman's statements, all of those that are now in evidence presented by the state, in assisting you in creating any portion of your animation?
The initial conflict, or the point where the conflict.
And was that specific to Mr. Zimmerman stating that he was struck?
Yes.
And in a location approximate to the location where he said he was struck?
Yes, where he said he was struck, backed up by General Lauer's positioning of the sound where the conflict started.
And back then, of course, you had, what did you have in addition to General Lauer's statement that you utilized to place the initial location of the altercation?
What did I have?
Who else did you have?
Jeremy Weinberg's police report.
Did you even have other witnesses who said the location was there, such as Jane Sudiker, who was in the apartment back behind the T? Did you have that information available to you?
Yes.
And was all of that then part of what you utilized?
Yes.
Was there any specific evidence that was found at the scene to assist you in determining that that was the estimate or probable location of the initial part of the altercation?
Yes. The first piece of evidence was the Mr. Zimmerman's flashlight keychain.
How did that assist you in laying out the location that is shown on the video, on the animation, about the initial part of the altercation?
It gives you a direction. So you have the initial conflict that took place at the T intersection. Then you've got the flashlight, which goes down to the direction where the next witness testified that they were located.
Okay. Mr. Manti many times suggested this is just an estimation. Will you acknowledge that if we look at that animation, it is somewhat of an estimation as to their initial location?
Correct.
But is that estimation in conflict with any of the evidence that you are aware of in the discovery that you reviewed?
Are you talking about their initial location? No, it's not.
If, for example, I was to have you recreate the animation of a shell casing discharge and the way it spins from out of it spinning to the ground, would you be able to create an animation that accomplished that?
Yes.
Would it, however, be an estimation to a certain extent of how many actual spins the shell casing may have made in its trajectory to the ground?
Yes, because that would be in the computer where you would rely on the physics in the computer to do the reconstruction of it. But even in the real world, when you do that with any gun, it's going to, each of the ejections are going to vary.
Is there an inherent estimation that exists in the entirety of your industry of, be it accident reconstruction or event reconstruction?
Is there
an estimation variable that exists in every animation that you make?
Correct. There's certain scenarios that you can create, but there's not an infinite number of scenarios. Those that are in conflict with the evidence, with witness testimony, those obviously can't be done that way. So the scenarios that can be created are consistent with testimony, witnesses, and evidence and the scene.
As an example, in your modifications of the animations, did you change, was a decision made in consult with me and others not to show movement of the bodies from the initial location until the location at rest? Was that a decision made?
Yes.
And why was that decision made?
Basically because from witness testimony, we know which direction they moved in, but it's not defined anywhere exactly how they got from that one position to the second, to the position by Mr. Good's condominium. So rather than try to create something, that's why I used the arrow to just show the direction that they had moved into the next position.
Was that then a decision by you as the creator of the animation to avoid creating animation that wasn't documented by witnesses?
Yes.
And then why did you then pick up again, and we're going to go to the last video and just use the stills, where did the information come then to place those people where they were?
The initial position, where it's labeled initial position, that came from John Good. The second position, that also came from John Good.
The initial position.
I'm going to back it up and ask him to, well, it was working. As soon as the projector warms back up, I'll do it, but I'll have him testify to that. Let's be careful that we all talk about the same positions. I'm going to make some definitions and tell me if we can live with those. Initial position was the event that started at the T intersection. Can we use that? Or do we want to define that as something else?
If we could define it as something else.
Okay, we'll define that as the T intersection event.
Okay.
Then tell us what you mean by the first event.
The first event is the first visual that John Good had on their position.
Okay.
It's labeled initial position.
Okay. Give me 1 second to convince your computer to work. Okay, that was the one where you had the testimony. It's about to come up here. The first position that you're speaking of.
It's going backwards.
Sorry, give me 1 second. I'll try and get it back to where it needs to be without sounding like the White Album from the Beatles backwards.
You can just grab the little white ball and slide it around.
Just don't use Max. Sorry. Okay. I'm just going to run it through to try and get us all caught up. This is the T intersection event we're talking about?
Yes.
And while we're talking about this, let's talk about some of the frailties inherent in the animation. You do not suggest that there is any witness that specifically identifies, for example, in this case, Trayvon Martin walking just along one side of the sidewalk. Is that correct?
Correct.
That is an estimation based upon George Zimmerman's testimony that he was approached from the left and the back?
Correct. And there was I didn't find any evidence or witnesses to dispute.
Okay. So then we have this. That information right there, where does that come from that gave you the foundation to create that portion of the animation?
From Mr. Zimmerman's video walkthrough and also from Jenna Lauer's and Jeremy Weinberg's police report.
And to a certain extent from Mr. Diker's also location of the general event?
Yes.
Okay. Now we see the arrow, which we talked about a moment ago. And is that what you had talked about being the arrow instead of having the actual figures move without any witnesses to identify them?
Yes.
Okay. Let's stop here for 1 second. This is what we now know to be John Good's sliding glass door.
Yes.
Based upon additional communication either with me or with him, was his position in the area of the sliding glass door modified?
Correct, it was.
And if you would advise to the court how it was and why it was how it was modified and why?
Initially, I had him just coming straight out from the middle of the sliding glass door. But after his refinement of his position, I placed him on the left side, the left sliding glass door, 1 foot out from the middle of the door.
And was that based upon the consultation regarding his specific testimony or his specific recall?
Gentlemen object to leading.
I'm just trying to move it along, but I'll change it.
Sustained.
What was it based upon, and what information was given to you and from whom that helped you modify it?
It was based on consultation with you and Mr. West on the feedback of Mr. Good in the placement of him in the scene.
Did Mr. Good, from our conversation, look at a animation and then ask for modifications?
Correct.
And is that the modifications that were changed on here?
Yes.
Now, this is where the 911 tape comes in, right?
Correct.
And there was questions concerning why the timing of the 911 call began. So, tell me, was there a point that existed in both Ms. Lauer's 911 call and Mr. Good's testimony as presented to you that was an intersection that allowed you to relate the two together?
Yes, it was the gunshot.
If I might approach the witness for a second, Your Honor, if you're going to see it as well. In effect, do we have a timeline of Jenna Lauer's 911 call with a gunshot at what you know to be about 45 seconds?
Correct.
Whatever it might be.
45 seconds.
And then do we also have a timeline of John Good's testimony and lining up the gunshot on his testimony?
Yes.
And if you line these two up, does that then give you a timeline from which you can estimate John Good's actions on the animation?
It's pretty much just taking the 911 timeline, taking the timeline which Mr. Good had with respect to the gunshot and just matching up that one event.
Let's do that for a moment from your testimony and trying to relate these two. What information did you have from John Good as to where he was when he heard the gunshot and what he had done how many seconds before that?
He was on his way up to make a 911 call, and the time that we had, if you go to the gunshot, you can, if you back up on Mr. Good's timeline, he gave an estimate on from when he went into the condominium till the time that the gunshot went off.
Okay. And did you then simply, if you will, calibrate your animation to Jenna Lauer's phone call, did you then use Mr. Good's estimation of how long it took him to leave the area he viewed until he heard the gunshot before? You are.
Well, I have a question, and let me interject, because in reviewing my notes, Mr. Good testifies that he also called 911, and he was on the phone with them and connected at or about the time of the gunshot. Was that used? Was that 911 call by John Good used in your comparison with the 911 call of Miss Lauer?
There was no gunshot on his 911 call.
No, but his testimony was he heard the gunshot while he was dialing 911, and in fact, I thought he said he was waiting for that call to connect. So we would know when that call connected in relation to the Lauer 911 call. So did you use that as your basis for the timeline of this 911 call and the testimony of Mr. Good?
He was still waiting for it to connect.
Yeah, my question is, did you use that? Did you consider at all in making this timeline in connection with the animation? That's a known time when he was calling. His testimony was he heard the gunshot while he was dialing 911. In fact, he was waiting for the call to connect when he heard the gunshot. Did you use his 911 connection in doing the comparison?
I used his estimation from how long it took him to get up to make his call.
Okay.
To further the court's inquiry, if you were to have the time of the phone call and estimate from there the time it might take to connect, would that help calibrate the animation even more refined?
Yes.
Okay. And would that be able to be accomplished tonight, for example, if I gave you the timing of the call?
I wouldn't be able to render and redo the animation, but I can I could do some marking when he came out.
Not to just discourse with you as you're on the stand, but if there was a few second difference, it would require simply moving the audio track of the Lauer call, would it not? And the animation would stay the same?
Yes.
Because that's the only relation, would it not be? As if the gunshot is relating the timing of Lauer's call, that would only change the audio track a few seconds one way or the other, would it not?
I believe it would affect Mr. Good's time that he went into the apartment or into the condo.
Well, let's go forward on that, presuming that your estimation of your use of his estimation as to how many seconds from leaving the view of the scene to hearing the gunshot is close to accurate. And
Well, go ahead, because I don't want to interject what my notes say, but I'll do that in argument when you're doing your argument.
Well, I don't want to miss an opportunity to clear up an inquiry. If we can, it's the three of us right now.
Is there any objection from the state?
Objection as to the court asking questions?
Yes.
None whatsoever.
Okay. My notes, and of course the record will correct me if I'm wrong, the only times that Mr. Good gave was that he was at home. It was between 7:05 and 7:15 p.m. when he was watching TV in his living room with his wife, and he heard the noise outside. The other times that he gives on cross was the entire time he was watching was 8 to 10 seconds. He doesn't say where within that time frame he saw the 8 to 10 seconds, but we do know from his testimony that he was dialing 911 and waiting for it to connect when he heard the gunshot. So I don't know how long he was in the house before that gunshot and he's dialing 911, and I don't know what the 8 to 10 seconds were if he says it was either 7:05 or 7:15. So the problem that I'm having to relate to that right now is the use of the Lauer 911 call in conjunction with Mr. Good's testimony. I don't understand where that timeline is coming from based upon John Good's testimony.
My understanding of his testimony, and again, the record, I'll need to review the actual transcript, was that he left the area of the view of the scene, turned around, and immediately grabbed his phone and started dialing.
What time did he go out there? At 7:05 or 7:15
He
or
went out
thereafter?
there,
Because I'll read you my notes, and of course the record is what
Yes,
is
Your Honor.
correct. These are just my notes. But he said it was between 7:05 and 7:15. They were watching TV in the living room. He heard a noise outside. First it was a faint noise, and he didn't think anything of it. He couldn't hear words. Then he heard the same noise, just louder, seemed like it was getting closer. He couldn't hear any words, and he didn't know if there was more than one person. He went to look out of his glass sliding door, which had the blinds drawn. He cracked the blinds. There was a light on the porch. He could only see someone or something out there. He opened the blinds and the glass sliding door. He took one step onto the concrete, looked like a tussle, could not see an object, and then he described how they were, the vertical on the ground. He yelled out, "What's going on?" Then my point being is he doesn't give another time other than when he heard the gunshot was while he was trying to connect with 911, so that would give us a time. And he said in cross that the entire time he was watching was 8 to 10 seconds.
Right.
Did that begin when he was looking out the blinds, the crack of the blinds, or did that begin when he took a step out onto the porch and observed that? I don't know. That wasn't testified to, so I'd like to know in this animation where Ms. Lauer's 911 call fits into his testimony.
I can tell you this, that his call connected at 19, 17, 15, that is in evidence.
So that's 7:17.
7:17 and 15
seconds.
seconds.
Uh-huh.
You know that Ms. Lauer's call started at 19:16:11, and that it is 45 seconds into the call, or at 7:16:56, that the gunshot goes off.
And that's
If you-
different from the timeline that you have up on here in connection with where he was and what he saw.
I disagree, but I understand the court's concern.
Well,
That of course, the way where I believe it lines up is if you use the gunshot as the precise moment of the two calls, not that it was on the call, but if it took Mr. Good somewhere around 15 to 20 seconds to get the call, place it, and wait for it to connect. We don't have that testimony, but we do have Ms. Lauer's testimony, who also testified it took about 20 seconds or so for her to make the phone call and connect. So if you...
Well, he didn't say he said he was waiting for it to connect. And we'll have to look back, I guess, in the record to see if my notes were correct on that or not. And I'm saying these are just my notes.
Sure.
But as I recall him saying he had dialed the 911 and was waiting for it to connect. So that a few seconds here or there, but then again, where's the 8 to 10 seconds that he viewed this?
And where's
Very-
the 30-second gap between the connection time and the gunshot call and everything else? The court has hit upon the central problem here, and that is there is no hard and fast ability to say that this is an accurate depiction. That's been the state's perspective all along.
Well, and the case law says it doesn't have to be exact.
But it has to be
And,
accurate.
so I don't necessarily have a problem with other parts of it. But when you're trying to overlay a 911 call with the animation, I think it has to be closer to exact than not closer.
I understand, and I might be able to fix that by recalling Mr. Good to get a couple of questions answered by him, so I want to make sure that focus, well, I have the right to, so
No, I'm shaking my
Oh.
head because we're having the hearing now.
I understand.
I'm
But-
not going to have this hearing go on for days and days. This
Let me
is the
just-
hearing now, and I guess I
could be-
should
my-
not have, can I please finish?
I'm sorry.
Okay. I guess I should not have commented because then this wouldn't come up and then I could just rule on it after you're finished. I'm not making these comments to cause you to call Mr. Good into this hearing. We have a transcript of what his testimony is, or we could have a transcript as to it. I'll stop talking, let you finish with your evidence, and then I'll make my comments.
I guess my response was going to be to the court that if it is accurate, and it seems to be undisputed and in evidence that Mr. Good's phone call was connected at 7:17:15, and that if we have evidence from Ms. Lauer that the decision to make a call to 911 and its connection is about 20 to 25 seconds, and that's in, then if you were to back it out the time, then I think you are within seconds of when the gunshot was heard on Ms. Lauer's call because of this reason. We know that the gunshot was heard per Ms. Lauer's call at 7.
Let me stop you here. I didn't mean to go into an argument. I'd like you to finish
Okay.
with Mr. Schumacher, and we can get into that.
An argument? Yes, Your Honor.
Yes.
I think we're at the point where we took some time that did you utilize Ms. Lauer's call and Mr. Good's testimony as to when, in relation to when he left the view of the scene, when he heard the gunshot?
Yes.
And is that how you then backed out the time, gunshot that Mr. Good heard, back in time and sort of went in reverse to when he was viewing the scene?
Correct.
And do you recall the time lag that you utilized in order to calibrate that back to the Lauer phone call?
The time lag between,
When he said, going forward in time, when he said he turned away from the scene to when he said he heard the gunshot?
I'm not sure the exact number of seconds.
Can you
That-
let the judge know then what you used in determining when to start the Lauer tape in relation to the video?
Well, in backing it out, his going back inside from the condo is based on consultation with you and from his feedback on the video.
Okay. So, does the necessity of being absolutely accurate, is that...
Whose feedback on the video?
Mr. Goods.
When did that happen?
Oh, consultation, in consultation with Mr. Omar.
Can you tell me what date that was?
No.
I can?
Was it after the trial started?
Yes.
He was under sequestration as a witness and he was subject to being recalled.
And I was going to have him view the video to document it, and he said there were
He
problems
was
with it.
consultation with changing parts of the video.
Absolutely. As an
Okay,
expert,
go ahead.
as an expert, Your Honor,
Mr. Good's not an expert.
no,
Mr. Good's a witness under witness sequestration.
absolutely. And he was being used to authenticate the animation, since it's his view. He had problems with it, and I attempted to address and fix his problems with it through this expert.
None of which, by the way, has been disclosed to the state until this moment.
Go ahead.
Let's then go forward with the animation.
911, do you need police, fire, medical?
Maybe both. I'm not sure. There's just someone screaming outside.
Okay, what's the address that they're near? Lane, is this in the Twin Lake Homes in Sanford?
Yes.
We just talked about how this was calibrated, but let's move forward to the initial position. What information did you use to identify this as the initial position of the two?
His comment about, the initial position of
This
Mr.
position we're
Zimmerman.
looking at now.
That was in consultation with you about some testimony.
Okay. And we also at this point, or did you change this from true animation to still?
Yes, just to eliminate, just to mitigate any random movements, because there was a lot of movements going on. So this was just to show the position, one person's position relative to the other person's position, according to Mr. Good.
And was this then done in order to make it more accurate
Yes,
and to avoid any or other inaccuracies?
yes.
Okay, and is it a male or female?
And then what was this change from the first position to the second position dependent upon?
Also based on consultation with you and from his testimony.
And again, no animation at this point to avoid the concerns you just talked about?
Correct.
It sounds like a male.
And you don't know why?
I don't know why. I think they're yelling help, but I don't know. Just send someone quick. Say stop.
Does he look,
And advise the court, if you would, how the determination was made to use the third position.
The third position was from consultation with Dr. DeMaio and also proximity to the prior position, which was just seconds before, and also to the items of evidence around that area.
Did it also include the final resting place of Mr. Martin?
Eventually,
And is the one we're about to see, that last position, then related to this third position?
correct, which is marker number 6, which is one of the things that comes into play on the position is also you have a slope there. So it's interaction with the slope.
Is that a slope that's better identified by one of the posters that were viewed by the court earlier?
Yes.
as we're talking about that, does your computer program have such physical laws like gravity in it so that things will fall in the way they're supposed to fall based upon gravity?
It does, but in this case, those physical properties were provided by the motion capture suit.
Kurt?
I can't see him. I don't want to go out there. I don't know what's going on. So they're sending him.
Again, was the decision at this point not to have animation a change from a previous generation?
Correct. It's just to show position.
And this is the position, I'll continue it.
So you think he's yelling help?
Yes.
All right, what is your serial number?
Before we move, this is the position that was modified based upon your conversation with Dr. DeMaio?
Yes.
And to what extent, again, was it modified?
Leaning over Mr. Zimmerman, just to verify that position with the
And
doctor.
was the leaning over something you got from Dr. DeMaio based upon his viewing of the clothing and whatnot?
Yes.
And what he discussed with you was his anticipated testimony
Correct.
regarding the clothing and the positioning of the bodies?
Yes.
Three.
That was 3 on.
Thank you.
And now it's about to go to the 4th.
There's gunshots.
And what you have identified as the after shot position? What information did you utilize to come up with that?
That was their position based on Selma Mora's report of what she saw after the shot.
Okay. Any other information, whether it be from Mr. Zimmerman's testimony, other witnesses' testimony, or eventual identification of the body location, was that used as well?
It was also consistent with Mr. Zimmerman's video testimony.
I see that there is a green circle. I've moved away from it to know the number. I think it's number 6. What is that green circle identified there for?
That would be the location of Mr. Martin.
Based upon what?
Based on the marker from their total station data.
Okay. All of these data that you use, these data points, are from their total station, correct?
Correct.
And what you added to was some of the grading?
The slope, yes.
To gunshots?
Yes.
How many?
This one. Jimmy, get down.
And why is it stopped right here at this location?
That's the location of Selma Mora, and it's also from that viewpoint. The video uses a 50 millimeter lens, which is what a person perceives when they're looking at something. So this was to show her vantage point and what she would see.
Okay. And then the screen goes black until the entirety of the Lauer call is completed?
Yes.
No further need for the lights, Your Honor, though I have some other inquiry. There was a concern raised about the lighting conditions. In your other experience with creating animations, are there times when you have to accomplish a lighting change or a weather change or something to make the animation worthwhile?
Yes.
Tell the court about that.
Well, if it's something about whether, if you want to focus on whether an eyewitness could really see what they saw, or the effects of weather on something, if that would be your main focus for a video, then you would create it that way. But the problem with that is, as you see in the courtroom here, there's ambient light, and it's really hard to get a totally accurate depiction of the lighting conditions. And
So
it'll vary according to what projector you use, and also even what printer you use if you're using posters. So in this video, the focus wasn't on reconstructing of the lighting, but it was more important to see what detail, the detail of what was going on in the video.
Was this animation then created with that, if you will, artificiality so that it could actually be viewed by those people who have to view it?
Correct.
Obviously, it's much lighter in the animation than it would be that night, correct?
Correct.
Did you attempt to make it accurate in other ways, such as utilizing proper weather that was available to you for that night?
Yes, I added rain to it.
What was that based upon?
That was based on historic weather data that I got,
And
that I
did you
received.
add any wind to it to the extent it may have had any impact?
I didn't add wind to this. It was 7 miles an hour going northeast.
Was there anything that wind, in your experience, that wind would have added to or subtracted to in an animation of this nature?
Not in this case.
You were asked whether or not the software calibrates itself, or somehow, how would you know that it's working accurately? Can you give the court any further insight as to what happens when the software doesn't work accurately, or when it crashes or does something that it's not supposed to be doing?
You can verify something easily by just measuring an object, that you know the size of that object and just measuring it, like you do in real world.
And have you done that in your animations generally?
Yes.
And have you done it in this animation?
Yes.
How is that done?
Well, if you want to measure the size of an object, you can just grab that object and choose the dimension tool, and it'll give you the height and the width of the object.
Is that also the way you recreated we'll call them avatars of Mr. Zimmerman and Mr. Martin, by getting their height and their approximate body size, and then using, what tool did you use to then create those avatars?
The figures were already created, so I didn't waste time on the creation of them, but I adjusted certain things on them to match the size of the figures and the clothing that they were wearing.
For example, if I was to be in your motion capture suit at 6'2", would you have to take that avatar and make it smaller to 5'11" to be Mr. Martin?
Correct.
And is that what was done to give them the relative sizes that they have in these animations?
Correct. And even though you're using somebody that may not be the exact size when you're making the recording, when it imports the motion file into the software, you specify an exact size that it will come into the software.
So you were able to make Trayvon Martin's avatar 5'11"?
Yes.
Okay. And putting on his shoes, whatever size his shoes might be, to give him that additional height?
Shoes and the top of his hood.
Okay. And do you know what the height turned out to be based upon those additions to his height?
Approximately around 6'2".
In the still that you used concerning the moment of the shot, with that view that you had of it, would a gun in Mr. Zimmerman's right hand have been visible?
No.
Would the flash of the gun have been visible from that angle?
No.
Would you have had to have created another animation from ground level or from just behind Mr. Zimmerman's head in order to show the gun?
Correct. If that was the purpose of what I was trying to create, to put all that information into a video or a still image, there would be a lot more attention to that. But in this, that wasn't the purpose of this video at all. There's other people that can testify to the gunshot and the positioning of the gun and all that. This was just to show the position of who was on top and who was on the bottom.
And what was the purpose then? What was the purpose of doing it limited to that?
Well, I believe that's the main thing. With Dr. DeMaio's input, the person that was shot had to be the person that was on top, and the person doing the shooting was the person that was on the bottom.
Just a moment, Your Honor.
Thank you, Eddie Recroft.
Thank you. As far as the representations of the figures in third position, I noticed that between second position and third position, the positions of the hips relative to each other change.
Correct.
Okay. As far as I know, that wasn't based on, at least you didn't tell me earlier, that it was based on any particular witness statement, testimony, or eyewitness observation. Right?
Some of that was based on common sense.
Okay, I'm sorry. Let's back up. And the common sense is that if you kept Trayvon Martin's figure positioned as he is in second position above George Zimmerman, there's no way that firearm would have been accessible to George Zimmerman. Isn't that what you told me?
In the second position where they were on the sidewalk?
Correct.
Correct.
So you had to move them in third position in order for the George Zimmerman figure to be able to even think about accessing a firearm that would have been carried on his right hip inside his pants. Right?
Correct.
And you didn't do that based on any actual testimony. You said you just did that to be able to put those figures in a particular position.
They were in position relative to each other. The position they were in when Dr. DeMaio mentioned about that, Mr. Martin being shot, and also accessibility of the gun.
Did Dr. DeMaio testify to your knowledge about accessibility of the gun?
That's common sense.
I'm sorry, did he testify about it, or is this just another assumption you're making?
He didn't. I didn't hear his testimony.
In fact, nobody did, as far as you know.
I didn't hear his testimony, so you're asking me about something that I had no knowledge about.
Right. You had no knowledge about it, but you included it in that animation.
The gun had to be accessible.
That's
That's common sense.
Well, if the gun had to be accessible, if we assume that in fact the figures were positioned as you had placed them. Right?
Correct.
So it's another assumption.
So that the gun is accessible.
Right. If, for example, the testimony was, or a statement was, or some evidence was, that the Trayvon Martin's figures were up at the armpits of the George Zimmerman figure, obviously the gun would in no way be accessible, right?
Not only the gun, the accessibility of the gun, but you're also talking about the position of the of Mr. Martin when he was shot.
So it would be impossible. So you're telling me you couldn't create an animation to fit that scenario.
With him straddling the shoulders of Mr. Zimmerman in position 3, no.
Right.
That's a scenario that wouldn't occur.
And as for position number 3, I think we talked earlier about in order to depict their angles, when you have the angle of the shot being, I think you put it 90 degrees earlier, straight in.
Yes, that's what the coroner, also in the coroner's report.
Okay, not left to right or anything like that, straight in. Right?
He mentioned 90 degrees front to back.
Okay.
But he mentioned 90 degrees front to back, but in my conversation with Mr. DeMaio, he mentioned 90 degrees, but slightly from, I believe he said very slightly left to right.
So you have notes of your conversation with Dr. DeMaio?
Just one.
Just one? Is that the only note you took?
Yes.
Just that about the 90-degree angle or not?
I already knew about the 90-degree angle from the coroner's report, so it wasn't, I didn't have to retain that.
What I'm asking is you just opened up a folder and looked at something. I'm just wondering what it was.
It was just my note on left to right from Dr. DeMaio.
Any other notes you have from Dr. DeMaio?
Just that.
Just that. Okay. So the position in position 3 that we've seen, we talked earlier about how the bodies had to be some distance apart from each other. In other words, the chests of the figures, for example, had to be a distance apart.
Correct.
Because you have to account for not just the clothing differential, right?
Correct.
You have to account for the length of the arms involved, right?
But you don't know what position the arms were in.
Exactly. And you have to account for the length of the gun involved, right?
Well, you're talking about a lot of different variables that I didn't portray in this video.
I understand. So none of them are accounted for here, right?
The main thing that's accounted for with this is Mr. Zimmerman and Mr. Martin, their positions, and the position of Mr. Martin over top of Mr. Zimmerman.
Yes or no, none of those variables I just mentioned are accounted for in any way in that third position animation.
Variables in relation to the bullet trajectory and the
spacing of the bodies, the lengths of the arm, the length of the gun, the distance of the gunshot clothing, all of that. It's not accounted for there because all you want to do is show the position of the bodies, right?
position of the bodies consistent with Dr. Mayo's consultation.
Okay. So no, none of those variables I just mentioned are accounted for in this animation, right?
The variables that you mentioned aren't impossible in this scenario.
Didn't ask if they're not possible. Is that what you said?
Are not impossible.
Okay. Is that a
There
way of
is
telling
space
me?
between Mr. Zimmerman and Mr. Martin in this video.
Is that a way of telling me that they are not depicted here in this animation?
They're in this animation, but they're not expounded to the point that you're talking about.
So I can tell from this animation.
You can tell.
I can tell from this animation the length of distance between, for example, the gun, the ground, the body of Trayvon Martin. I can tell all that from this animation.
If you use photogrammetry, if you know the measurement of one item, you can figure out the measurement of the other.
I'm not talking about what else I would have to do. I just want to know if I can tell it from this.
The figures in this are to scale. So if you're looking at this scene and you wonder about the size of the individuals involved, they're to scale. So there's nothing that has changed throughout this video in relation to the scale of them.
They're to scale in terms of their height, right?
Correct.
And that's it.
They're to scale in terms of their height and their appearance according to photos that I received.
I thought you told me you didn't take measurements of the other parts of their bodies.
I had coroner's photographs of Mr. Martin.
I'm asking about other photographs. What I'm asking about is, does this animation show me, can I tell that spacing and those lines just from watching this animation, or do I have to go delving deep into the data that you've compiled underlying that program?
If you knew how to do it, you could tell it from the video.
Let's assume I don't. Let's assume the judge doesn't. Let's assume that the jury doesn't.
That wasn't the purpose of the video. That's why you're not looking at what you're trying to look for.
Thank you.
You're looking for something that's not in the video and expecting something that wasn't the purpose of the video.
It's not there, right?
The purpose of the video isn't to examine the bullet trajectory and the location of the gun. The purpose of the video is to show relative positions from one person to the other and the position of Mr. Martin on top, where he had to be consistent with Dr. DeMaio's testimony when the gun went off.
Would it shock you if Dr. DeMille might have testified that there was another position possible for those two bodies?
He mentioned that there was a variable of about 2 inches.
That's it?
Correct.
No other questions, Judge?
Thank you. Any redirect? May Mr. Shoemaker be excused?
Yes.
Thank you very much. You're
Thanks.
excused. Any other witnesses from the defense?
No.
Any witnesses from the state?
No, Your Honor.
Let's have argument. This is from who?
The state.
Okay.
Are we in a presentation under Daubert that you want that initial, or are we talking about applicability to this case in this animation now? It seems we've gone one to the other and maybe back.
Yes, we have. The state yesterday had indicated that it was not a Daubert issue, and this morning indicated it was a Daubert issue. So I don't know where the state stands as to the request regarding that.
As I put in the second supplemental motion this morning, I do believe that there needs to be a Daubert analysis or Daubert-Frye analysis, Frye, of course, now being essentially one component of Daubert, so I think we can handle that, as well as a Pierce factor analysis. I think both of those have to apply to this, both the testimony and the animation. So I'm asking for both.
Under Frye and then Daubert, the main consideration with Frye, of course, is that is it generally accepted in the community? I don't think there's been any counter argument from the state that this is a type animation, though it's a new generation, that the underlying foundation of this animation, which is the idea of taking data and incorporating it into an accident reconstruction or an event reconstruction event, has been admitted in courts a lot. It's been by this very witness. He's testified for the last 14 years in this. He's never been disqualified as an expert upon his attempt to have it in. I will acknowledge to the court that I did not present an enormous amount of industry-wide evidence because, quite honestly, I did not realize that it was going to be a contested issue today. However, I think even this expert alone has presented that that in his industry, he stays up to the day-to-day or week-to-week information flow concerning the accuracy of the data and software that he uses, that he has been involved in the industry since, I think, 95. And for the past 14 years, he's focused his inquiry and profession on this area, and that he's presented many, many times, and again, has never been excluded. So to the extent of whether or not it is generally accepted, I would suggest that it has been and is. Under this now new sort of Daubert inquiry they look at, I think for the purpose of this inquiry, I think the court needs to look at this and say, even though it has been generally accepted in the past, would it assist here today? And that is sort of a Pierce consideration as well. Will it help this jury in a consideration? I do think that as to that, and we're going to do a sort of a Daubert-Pierce analysis together, because I think what needs to happen is that this court needs to be convinced that it's accurate, and not that it's perfect, but that it is accurate depiction based upon the information available when it was created. It has been, of course, created and recreated several times. With the most recent generation of it was, in fact, based upon some trial testimony, because I perceive that an expert has not only the right but the obligation to make sure that their testimony they're going to present, in this case basically the animation, uses the most up-to-date information available, and that is trial testimony. It's difficult for the state to argue it's not based upon trial testimony and then say that he can't have the trial testimony available to him, even through consultation with counsel, to make sure that it is as accurate as it can be. Within that context, we have taken away some of the frailties of the animation. And that is, it's no longer really an animation, but for the initial animation of the initial strike by Mr. Martin against Mrs. Zimmerman, which came solely from his testimony, but all of that is in evidence now. And
where's the testimony that Mr. Martin is left-handed? Because that animation at the T shows a left-handed punch.
the strike, the injuries to the left side, the right side of Mrs. Zimmerman's body, and he had testified that he had gotten struck by Mr. Martin when he first looked up and got struck, and the injury was right here. That's where it's from. And quite honestly, to the extent that the jury has to look at that and say, I think that that is absolutely the most reasonable assumption that they can make. Never did he say he was right-handed. I don't care if he's left-handed or right-handed. As to that fact, he hit him with a left hand because that's the area of the
Who testified
impact.
as to that?
Mr. Zimmerman.
He testified he got punched in
Right.
the face. He
And the
didn't
injury,
say,
I'm sorry,
he didn't say from what hand.
that's correct.
Nobody testified that that injury came from a left-handed punch. And Sabrina Fulton testified that Trayvon Martin was right-handed. So I don't have any testimony in the record to show that that was a left-handed punch.
May I give you the
Yes, you
my
may.
insight? Dr. Rao testified. I'm sorry. Yeah, Dr. Rao testified, and she gave us a graphic identification, and she also testified that the injury came across the nose. We have to realize, of course, Mr. Zimmerman facing Mr. Martin, so you know what I'm talking about with the positioning of them. It was Dr. Rao who testified that the punch came in this way. She actually said it went up, which we have contraindications of by Dr. DeMaio, but she testified that the punch came in effect, from left to right because it hit him right here, and she testified that the abrasion was on the inner right side of Mrs. Zimmerman's face caused by the knuckle. So to the extent that you're looking for evidence to support that, certainly there's no evidence to support anything else. Ms. Fulton said, my son is right-handed, but that means that might be the hand you want to use first. I don't know. But the specific evidence from the medical examiner, Dr. Rao, was that it came from the left side and hit Mr. Zimmerman on the right side of his face. So that is what is the basis for the left strike in that animation.
So are you saying that nobody could ever hit somebody with the right hand and cause that injury coming from the left side?
Well, I think that, I tell you what, yes. Now, I don't know if that means that the animation is invalid, but I just have to get it this way by asking Mr. Manchow to stand up for a second. And if he's going to swing at me with his right hand, I suppose if I turn this way, somehow it might come across. So yes, it could be. But since we only have Mr. Zimmerman's testimony that they were basically standing in front of each other, that he approached him from behind, Mrs. Zimmerman turned to him, his testimony does say that, reaching down to get his phone, looked up and got hit. That testimony seems to be that they were face to face. Could Mrs. Zimmerman have turned all the way around this way and then Mr. Martin's right hand got him like that? Yeah, that's a possibility. I think that the testimony would suggest, both when we look at Mr. Zimmerman's testimony that he was basically face to face and Dr. Rao's testimony that the more likely event was a left hand throw.
I didn't hear her say more likely event it was a left-hand throw.
No, I just said that.
Okay, you said her testimony was.
Oh, no, I said with her testimony.
Okay.
Then there was my words, it's more likely a left-hand throw. So that was where that part of the animation was created. So we have that part of the animation, and then we took out some of the more concerning parts of what is animation, because after that part of the animation, really what it is still photos or still animations based upon specific testimony. And yes, that was modified based upon John Good saying in his testimony that it happened in certain relation to the 911 call of Ms. Lauer, which is why that was placed in to give context to it. And the main reason for that context is because we know that we have a reverse timing of when...
Let's talk about Ms. Lauer for a second, because in my notes it does not indicate that she saw anything.
No, of course she did not.
And Mr. Schumacher is testifying that the testimony at the T, or the figures at the T, is based upon her... I don't know if it's the first illustration or whatever. It's based upon Ms. Lauer's testimony. She's never said that she saw anything.
No, she said she heard.
Well, but hearing and seeing, and the animation is presented by Mr. Schumacher, he said, based upon her testimony. If
Of where
we
she
all
heard.
only know what she heard and none of us know what she saw, how do you get that position in?
Okay. Here's my response. Ms. Lauer testified that she believed that the altercation that she first heard, which was the back, forth, and back conversation, occurred out of her condominium to the left near the T intersection. I can pull up her exact testimony because I think we actually have it, but generally
She testified on that date the bamboo blinds were drawn down. She and her husband were at home around 7 p.m. She was watching TV in the living room. She was on the love seat facing the glass sliding door. Whether it was raining, the glass sliding door was open. Her view to the backyard was obstructed at night by the blinds. She heard voices from outside her backyard, couldn't tell the words. The voices were coming from her left, sounded like a loud talking. Voices sounded like the same volume tone, more flustered than confrontational. She muted the TV. She heard scuffling around like sneakers on pavement or grass. Combination of pavement and grass. She gradually went to a grunting noise. It gradually turned into grunting. At first it sounded like people standing up, and then sounded like wrestling, rolling on grass. And that's when she decided to call 911 as soon as she heard the scuffling noise. And it took her about 30 seconds to connect to 911. She didn't say she saw anything. She could tell the voices were coming from her left. And she could tell that it got closer because it got louder. First vertical, then they were scuffling around pavement and grass.
She never said she saw anything at all. That animation is placed in that location based upon what she said, where she heard it come from. And I think if you go further in your notes to where the cross-examination occurred, I talked to her about the first, there were the three parts of the conversation, sort of like the red car, blue car, red car was the way I presented it to her. So hopefully those are in your notes as well, because in my conversation with her at that point, I focused her more on the beginning, the initial conversation beginning at the T intersection.
My point being that animation position, Mr. Schumacher said, is based upon Ms. Lauer's testimony.
Of what she heard, where she never saw anything, but she heard it.
Okay, can I see that position again? Oh.
Would they still work?
Yes, it would help.
Okay. Yeah. 1 second, I'll just give you something. to look
Thank
at.
you.
If I might, you see,
Is that the new one?
this is the one you have. If I might approach you.
Please, thank you.
So that's her trial testimony that was.
Can I keep this up here
Yes,
so I
please.
can refer back to it? Thank you.
So in any case, that was, you're right, she did not see anything. And yes, in that sense, the particular placement is an estimate on voice. But I think in her cross-examination, when I cross-examined her, she was more specific that it happened in the area of the T intersection. And is it 4 feet away, 6 feet away? But that is a frailty of the animation based upon non-visual testimony. So then the question under this Dauber-Pierce matter is it accurate? And we're talking about that now. The other accuracies of it were limited by, we used John Good's specific recollection as to he testified at trial to these sort of 3 different positionings. That's where we got it from, where he said first they were sort of vertical, then they were sort of, he didn't get the words right, but parallel and on top of the pathway, and then they were further down, and that's where 1, 2, and 3 come from directly. Then he left. And we kept him in that position because there is no other evidence to support changes. Could they have jumped up, gone 10 feet, and run back into the same position? I guess so, but there was no evidence to support anything but what John Goodlast saw, so we kept it static. And then the positioning was changed slightly, and only, I think, from more like this, which was the mounted position that we saw before, to more like this because of Dr. DeMaio's anticipated testimony that the shot went in, but that the gravity effect of the shirt and the can in the shirt and how that would pull it down made sense. Again, I argued to you yesterday when we were talking about this, could it be like this? Yes, now we know from Dr. DeMaio's testimony it might be like this, but that as the bodies go up, then the can pulls it more straight down, and so the idea of having it billowed with gravity means it's more like this. Is it an estimation within that context? I acknowledge that. But at least Dr. DeMaio's testimony lessened the angle much more so because of the gravitational effect on the can. And that's quite honestly it for the animation as far as whether or not it's accurate, because that's a premise for whether or not it would assist the trier of fact. And I would suggest that with all of the information that we have in this case, and with the various witnesses, none of whom are direct witnesses except for Mr. Good, but all of whom have almost as vantage point changes to offer to it, that an attempt by the defense to present that in a way that does in fact support the defense presentation of what happened, and we have now, I think, presented an enormous amount of evidence to support that that animation is accurate and would help the trier of fact in presenting the way the defense says the case happened in comport with the facts, that it would in fact assist the trier of fact in trying to get an understanding, a graphic understanding as to how the situation unfolded that night and how things may have ended. So to the extent that Pierce requires that, I think
But the distinction in Pierce is that the state, whether it's the state or defense, is not the distinction. It is that the state intended to introduce that into evidence, and the court ruled that it would be demonstrative only. And it seemed to make a difference in the analysis that the court did based upon that, because it did not go back to the jury as evidence in the case. It was used for demonstrative to assist the expert in their testimony.
I agree that's what the Pierce court did. I did not find that the Pierce court outlined an exclusion for it becoming evidence, just as the state has entered into evidence their timeline. If it is accurate, if it would assist the trier of fact, this court has already, in this case, allowed a presentation to be presented by the state in putting together various facts in a graphic way that I presume that they believe assists the trier of fact in some way that helps their case. That's exactly what an animation is, and there's no reason why it shouldn't be admitted into evidence. I do agree with the court. I think Pierce made a distinction between the two, but I don't know that it was a ruling that I can't imagine it being a ruling to suggest that information cannot be entered as evidence. I think in that case they decided not to. Just to make sure that we follow through the criteria of Pierce, I do think that he was qualified as an expert. He's been qualified in another state and counties before, and that it is certainly applied to the evidence offered at trial. Again, Pierce, while it says that, we know that it's not strictly limited in that the evidence has got to be, the animation has got to be consistent with the evidence. It can't go into some matter that is not otherwise presented to the evidence. It can't show something that for which there is not an evidentiary support. Does it need to be a perfect frame-by-frame rendition of the evidence? I don't believe that Pierce or any other case suggests that it needs to be that. It just needs to be accurate. It needs to fairly depict the circumstances to which it suggests it does. And are there frailties to it? Yes. Is one frailty the fact that if this was in real light, it would be all dark and black? Yes. is that something that I would then need to explain to the jury, as with every other piece of evidence? You have to take it into context. A gun out of a holster doesn't mean anything when the evidence suggests a gun in a holster? Sure. But that doesn't mean it's a fatal frailty of the evidence. It just simply allows the jury to see what could have been seen by the witnesses, and then they can extrapolate from that to the darkness that we all know existed. So anyway, under that context, I think that we've met Fry, now Daubert, and even though Daubert sort of suggests that if otherwise generally accepted in the community, this court can act as, in effect, a gatekeeper to say, I'm not letting that get to this jury without a further foundation of its acceptance and relevance and assistance to the jury, that we have proven that.
Okay, thank you very much. Mr. Montine?
Your Honor, the state's position is that this animation is a supposition inside a riddle wrapped in an enigma. I've provided the court with two sets of cases, one of which is essentially more Daubert-oriented, and the second of which is Pierce and a companion case from the state of Florida. I'm going to start, if I may, with the Daubert line of cases. First of all, the burden's on the defense to satisfy this court by preponderance of the evidence that the standards required for admission of this type of evidence have been satisfied. In Valenti v. Textron, there's the reference, and I'll refer to court, it's Valente, which is the first case in the stack I've given you, a 2013 decision from the United States District Court, Eastern District of New York. But essentially, what I want to refer the court to is the second page of that opinion beginning in Headnote 3, where they set out the sort of Daubert factors. There are a number of them. They are neither exhaustive nor necessarily all-inclusive. However, the ones that have been designated are, number one, whether the theory or technique has been or can be tested. Two, whether it has been subjected to peer review and publication. Three, the technique's known or potential rate of error, and the existence and maintenance of standards controlling the technique's operation. Four, whether a particular technique or theory has gained general acceptance in the relevant scientific community. And I would further posit that then there becomes a question of whether the methodology is either proper for this case or properly applied to this case. In other words, the relationship of the technique to the methods which have been established to be reliable, and then the qualifications of the expert in question. For starters, no witness, or nobody actually, even including this witness, if I understood his testimony correctly, he has never testified before in a criminal courtroom about exactly the sort of thing that he is attempting to testify about here. He has at times put things together or consulted with attorneys, but this is the first time ever with these motion capture suits in conjunction with the other things that he did, that he is attempting, even he, attempting to do this. And nobody else, by his own testimony, in his entire industry, does exactly what he does with the same methodology and same equipment. Now, we could quibble about whether or not all this is a new generation, but that's not what the witness said. What the witness said was, I've never actually testified under circumstances like these before, about circumstances like this before, nor do I believe, since I'm the only one who does any of this, that anybody else has. And he's kind of right. Secondly, as it relates to this, I'm going to refer to the next page of the Valenti opinion, where they go on to quote some additional cases, but at the very beginning, top of that left-hand column, they give you a quote from GE versus Joyner, which was the United States Supreme Court case from 1997. Nothing in either Daubert or the Federal Rules of Evidence requires a district court to admit opinion evidence which is connected to the existing data only by the ipse dixit of the expert. Court may conclude that there's simply too great an analytical gap between the data and the opinion proffered. And I submit that's sort of what's going on here, and we've been having these conversations about the gap between the data of the 911 call vis-a-vis the animation, and the gap between the actual testimony of witnesses. And
Let me interrupt you just
Yes,
because I interrupted Mr. O'Mara, and I don't mind interrupting people.
Fair is fair.
What would be the difference if this Mr. Shoemaker came off the stand and did a drawing of what he considered to be the crime scene investigation? The computer just is assisting that drawing.
Well, I put it this way. It's not exactly just assisting the drawing. This witness couldn't draw a correlation between alleged 911 recordings and the perspective of another witness.
Well, I'm not talking about that. You're talking about his use of the computer program and software. I don't agree at this juncture that is necessarily falls within the Daubert test, because this witness could make those drawings. The issue of relating the 911 call to the animation, it may be a different argument. But what would prevent the defense from having this witness testify to crime scene reconstruction, get off the stand, take an easel board, make a drawing, and at the same time having that witness playing the 911 call and saying to the witness, could you point to where you believe that these events occurred on there?
We wouldn't.
That's the difference between whether it is a Daubert or it's just an admissibility issue.
The best answer I can give the court is we wouldn't have to be worried about whether or not the drawing is purported to be accurate. The reason that this animation is being asked to be used as substantive evidence, as well as a demonstrative aid, but substantive evidence, we wouldn't have a witness step down, draw something on that easel, submit it as an exhibit.
Let me interrupt you again.
Yes, Your Honor.
If the court were to allow it only as a demonstrative evidence, would you have the same argument?
I would have the same argument from a different point of view. In other words, I think the standard is much higher for submitting it as an actual exhibit, and I think there are more hurdles to jump. I would still be objecting for some of the same reasons, although not all.
Would you be objecting for a Daubert determination if it were demonstrative?
I think probably not, because I think Daubert really applies to evidence that's going to be given to the jury. If I'm assured that it's not going to be given to the jury, I think since it wouldn't be testified to, it would be, if we're talking about using it as a demonstrative exhibit, the witness who would do that, Dr. DeMaio, about the position of the bodies and things, has already testified and done, and he didn't need it. He testified quite clearly to his positions on, or his beliefs and opinions about the positions of the bodies and things like that, without even referencing this. He didn't need it. All the other witnesses testified, and they didn't need it. So I would say that I wouldn't necessarily mind if counsel wants to use something sort of like this, I guess, as part of a closing argument, if that's the kind of demonstrative aid we're talking about. But I think my objection to it being a demonstrative aid is one of the foundational issues in that regard is it necessary for the witness to help explain their opinion? And the only witnesses who would need it have already testified and didn't need it. What we're now talking about, I guess, if we're talking about, for example, the idea that Mr. Shoemaker would come in here and use this as a demonstrative aid to explain his own testimony is only a function of what he's been told by the lawyers and everything else. There's nothing that would be required for the witness testimony to be explained by this. It would simply be a reinterpretation of what has already gone before by that witness. That would be inappropriate from the state's perspective. That's not the use of it. That's not the purpose of a demonstrative exhibit. So that's a long answer to the court's short question, but I think I made that position clear. It depends on sort of demonstrative aid meaning exactly what. If it's used by counsel in closing argument, different story and a different analysis altogether. If we're talking about a witness, not Mr. Shoemaker, coming up, playing this thing and telling everybody what he thinks it means, yes, I do have concerns about that. And I think some of them are Daubert related. But he wouldn't have to, if it's not substantive evidence, meet every one of the Daubert prongs. I'll agree with that.
Go ahead.
Okay. There has been no testimony offered or presented so far as would be the defense's burden, about the known or potential rate of error, the maintenance of standards, anything about peer review and publication. What we've heard is that they use it for the movies. Great. This is a murder trial. This isn't Casablanca. I mean, we're not talking about, this isn't Iron Man. It's one thing to say, I'm going to strap suits on people and create a complete work of fiction. And it's another to say entirely, I'm going to create something that while it is fiction, I'm saying is a representation of a certain perception of reality. Those are two very different things. So there's been nothing submitted as it relates to whether or not these things satisfy those prongs. Further, I'll continue in the Valenti opinion over to page 6 of the court's opinion. And it's under head note 8. And again, they begin quoting another U.S. Supreme Court case, Kumho-Tyer, 520, that's Kumho. The reliability of the expert's methodology in reaching his conclusions must be evaluated against the specific facts at issue, not generalized theories. And down further on the bottom of that page, in other words, simplifications that are permissible to recreate a collision may not be appropriate to recreate, for example, a non-impact rollover. The reasonableness in general of using a specific methodology does not mean that using the methodology is reasonable to draw a conclusion regarding the particular matter to which the expert testimony was directly relevant. Validation is the process of making sure that despite the simplifications that have been made, the model still accurately predicts the way the object is trying to simulate behaves. Never a more clear illustration of that than, for example, the very beginning of this video, where the evidence and actual testimony is that A, Trayvon Martin is right-handed, where the witness is apparently under the impression that he is in fact left-handed. Again, just going to we want to talk about frailties. This is getting to be so frail it needs traction. The idea that you assume, based upon the location of an injury on the body, that it was struck with a certain thing in a certain manner is an invalid and unwarranted assumption based on the evidence. It is not hard for a right-handed person to punch someone on the left side of their nose. It requires a half step, a side step, a turning of the head, any number of things. But to sit here and say that it is a punch with the left hand, to depict it graphically and say it is my expert opinion that this is how it happened, without a foundation in the evidence, is exactly what they're talking about when we talk about a lack of validation and the lack of the ability to apply the generalized methodology that we use to make movies to the particular facts in this case.
Well, that's not a methodology issue, that's a fact issue. That's the applying the facts to, inputting the facts into the computer.
And more importantly, creating a result once you have input those facts.
But it's a fact, the inputting of the facts that's the issue. It's not the computer's going to do whatever you tell it to do. So if you tell it to do A, B, C, you're going to get that result. If you tell it to do D, E, F, you're going to get a different result.
And if your methodology is to make assumptions that aren't warranted by the evidence, then that is the problem.
But that's not the computer. That's the assumptions being made, the input into the computer.
Agreed.
Okay, thank you.
That is a large problem here as well. Moving to page 8, again, peer review. There's been no testimony about that. Page 9, error rate, unknown, cannot be determined. No testimony about it. Nothing involved in this case. Moving to page 13, the next factor, reliability and relevance. They're talking in here about a particular expert, one of several that were discussed in this case, and I'm going to refer to the right-hand column beginning with the first full paragraph. In this case, that expert merely reiterates without any basis the conclusions that plaintiffs seek to advance in this litigation, which is not proper expert testimony. Expert testimony should not merely reiterate arguments based on inferences that can be drawn by laypersons. Those can properly be advanced by the parties in their summations. That is, again, exactly really what this is it is an attempt to have an expert in graphic design come in here and advance the arguments that are being presented by the defense, both most of his input coming directly from the attorneys. I won't even get into the whole violation of sequestration issue at this point. Or from a 20-minute phone call to a witness who hadn't testified yet, and I think the court has figured out by now, his testimony today isn't exactly what this witness had expected it to be. So when you've got the situation where the expert just comes in and reiterates the arguments, the positions of the bodies, the space that must be between the angles at which they must be, the particular placement of the hips, those are arguments. There's no eyewitness testimony to any of that. Those are arguments that are being advanced by counsel based upon what they claim are inferences. The gun had to be accessible, so it's common sense inference. Well, that's a question for the laypersons on this jury. That is something they should be doing, and that is something counsel can argue to them, but it's not the proper subject of expert testimony. I'll move to, I think it's the third case, and that's the Scordill, S-C-O-R-D-I-L-L case, which is a district court opinion from the Eastern District of Louisiana. And again, these are cases that sort of discuss the applicability of Frye factors to situations such as we have here. And it's beginning on, I think it's page 5 of the copy of the court's opinion, under B, demonstration videos. Beginning in that second paragraph, the standard by which the court determines the admissibility of experimental evidence depends on whether it is being offered to reenact the accident or demonstrate general scientific principles. And here they're talking about experts who went out and sort of conducted a filmed experiment based upon what they believe was their theory of the case and tried to match it closely. Continuing into the next column, if an experiment recreates conditions similar to the accident but does not intend to replicate it, the court will balance the probative value of the evidence against the potential for misunderstanding by the jury, take steps to minimize the misleading effects. Further on down the line, and here we get to sort of a Rule 403 analysis, at the bottom of the last, or the beginning of the last paragraph on the page, the court concludes the video demonstration is likely to confuse and mislead the jury, and its prejudicial effect substantially outweighs its probative value. The idea that you don't have to be exact is correct. I'm not saying that essentially if we don't have a contemporaneous movie made of the incident in this case, that nothing could be advanced as a demonstrative aid, for example. I will quarrel about whether it can be substantive evidence. But that's not really the standard. The idea is if what you've got is not accurate enough, and in this case it's not enough to simply say I'm generally in the vicinity, I'm in some proximity. They are the figures in this case and the positions of the case and the positions of such things as their hips and the length of space between them such that whether firing a gun is possible. Those are all intentional assumptions and all intentional things placed into that animation. They were done with a purpose, and they're not necessarily accurate or based on any actual testimony. The problem is that their arguments masquerading as evidence. The next case is the Salvatore case. That's S-A-L-V-A-T-O-R-E. And I'm particularly talking about page 5 of that opinion. And here again, we're talking about attempted video accident reconstruction. In this case, they talk about the witness themselves, talking about there's, I believe it's note 7 there in the left-hand column. With regard to the simulation, the witness in that case, Cusumano, C-U-S-U-M-A-N-O, would not be qualified to provide a video attempting to reconstruct the accident. He's not an accident reconstruction expert or a biomechanics expert, holds no degree in engineering, not qualified to provide an opinion as to the accident reconstruction. Now, I have heard that this witness has testified that he has done reconstructions and been accepted as such before. The bottom line is he's a graphic designer skilled in manipulating software and making movies, but actual reconstruction of events within a crime scene as opposed to reconstructing the parameters and static elements within a crime scene, I would submit, are two very different things. Most significantly, I'll point out to the court that when this witness has testified before, what he said was, I do things like I analogize bullet trajectories where I can take mathematical measurements and draw exact lines and extrapolate the positions of figures from those exact things. Not I put people in positions based on surmises of experts or other witnesses. Down towards the bottom of that column, the last paragraph, there's a higher threshold for admissibility of visual demonstrations that attempt to recreate an accident because they are significantly more likely to confuse the jury than depictions which merely illustrate principles forming an expert's opinion. Again, the expert opinion referenced in this videos are not those of Mr. Shoemaker. They are, if anybody, the only expert opinion is that of Dr. DeMaio, who didn't need it, didn't talk about it, didn't reference it, testified without it. And then continuing in the upper portion of the next column, thus for demonstrative evidence closely resembling the actual incident, courts generally require the proponent to establish that the demonstration shares substantial similarity with the accident conditions. By contrast, if a demonstration does not appear to recreate the accident, Rule 403 generally does not require a foundational showing of similarity with the accident conditions. This is being purported, at least, to be a recreation of this crime scene or the events taking place within this crime scene. That being said, the higher standard applies. And if we accept the higher standard applying, the conditions aren't anywhere near close enough. We'll start with the obvious, the lighting. We'll start with the more obvious, the depiction of visual positions, not based on any eyewitness testimony, but based on a 20-minute phone conversation with another witness who sort of described his general theory about how it must have happened. That's not a substantial similarity with the actual conditions. The idea that we have no idea how we go from the T 40 feet down, so we'll just throw an arrow out there, doesn't explain or doesn't say that this is a substantial similarity to condition. What it says is, I don't know. And that's really where it ought to stop. Further, even as it relates to Dr. DeMaio's testimony, his opinion as he testified today was that at the moment of the gunshot, he believed the defendant's statement was consistent with what he understood the physical evidence to be. Not even that it is how it happened, not that it was the only way it could have happened, only that his interpretation of the defendant's statement, that is Dr. DeMaio's interpretation of the defendant's statement, in his opinion, was consistent. Mr. Shoemaker is taking Dr. DeMaio's statement to him about a statement of the defendant that Mr. Shoemaker claims he didn't use in connection with position 3, the position of the shot, at all. He said the only time I used anything this defendant said was as it relates to that first punch. That was what he testified to. So we're, again, talking about sort of relay through relay through relay. That's not the standard for the admissibility of this evidence. Further, I think as it relates to the Daubert issue itself, if this evidence is admitted either as substantive evidence, which I submit it shouldn't even be considered for, or even as a demonstrative exhibit, the court should fashion a significantly strong admonishment to the jury along the lines of this is not a pretended to be an accurate depiction of the events. This is a representation of a possible scenario. So even if it's submitted in some form to the jury, they ought to know that this is not being testified as this is how it happened. And nobody should represent that it is, nor should they be confused by any indication that it is. If we were talking about simply some stills created by Mr. Shoemaker showing the location of physical evidence, and without figures, probably wouldn't have a problem with it. Even when we start to add figures, as long as the figures aren't purported to have significance in certain ways that they are depicted, in other words, I depict the arms doing certain things even though I don't know how long they really are and whether it would even be possible for them to reach somewhere given a certain angle of a body, like the video depicts them doing. Or their hips are in a certain position just because I know that there must have, common sense tells me he had to have been able to access the gun without any actual evidence that that's where they were.
I guess that's where Mr. O'Mara, and I need to interrupt you,
Yes, sir.
Mr. Manti.
Yes, Your
Mr.
Honor.
O'Mara, I'm trying to figure out the purpose of the introduction of this animation. I don't see where it's assisting an expert in testifying as to what happened. Can you respond to that, please?
Yes.
Mr. Manti, I'll get back with you.
Sure. The animation itself is substantive evidence because just as the state has taken a distillation of other pieces of evidence that they wanted to present to the jury in a format, that's what this is. The reason why it's substantive evidence is that it takes pieces of evidence that exist, various witness statements, and it puts it together in a way that does assist the jury because what they did is they've taken certain pieces of evidence from Mr. Zimmerman's statement regarding the shot to Dr. Rao's testimony concerning the injuries and put it in context with everything else that was happening, run, in effect, a timeline, just as the state has already presented.
But your animation does more than a timeline. Although you voice over the 911 call, the Lauer 911
Yes.
call, the animation does more than a timeline. It's depicting positions of Mr. Martin and Mr. Zimmerman based upon
John Good's testimony.
Pardon me?
John Good's testimony. I mean, in effect, I'll give you an example to compare it to, we have before the jury one of the witnesses, Adam Pollock, mounting me. Was that exactly how Trayvon Martin mounted? No. But it's an example and it instructs the jury in a visual way how it could occur. We have Ms. Morris prance around the courtroom to give an idea.
But the jury's not taking that back with them into the jury room to play over and over and over again as how a reconstruction of what happened.
Well, they do have the state's compilation exhibit that they put into evidence, which is their timeline on top of their timeline, on top of phone call and whatnot. So they've distilled down.
But they did not interject animation figures into that timeline as to what was happening with the two individuals during those calls.
Certainly, this is an animation depicting what happened during those two individuals based upon John Good's specific positioning of those people.
Well, it's more than that. The animation's depicting a lot more than that, based upon Mr. Shoemaker's common sense, based upon an assumption that Trayvon Martin hit Mr. Zimmerman with his left hand,
Yes.
based upon a phone conversation with Dr. DeMaio that was not necessarily his testimony in court. So it does a lot more than that. Dr. DeMaio testified that the position of Trayvon Martin could have been at different angles. He could have been leaning down or he could have been pulling back. That's my recollection of the testimony. So I need you to respond to
My
that.
understanding of Dr. DeMaio's testimony was in response to them saying could have been pulling back and George Zimmerman pulling his shirt. Dr. DeMaio said, well, no, that would pull the shirt to one side and then the bullet markings wouldn't match up. So I don't think that Dr. DeMaio gave the alternative suggestion that is now being propounded
Well,
by
I
the
think
state.
Mr.
but-
De La Rionda had asked him, given the fact that Mr. Martin's sweatshirt or hoodie may have been wet, and the fact that he had a full can of, I don't know how many ounces, in his pocket, may determine the position of his body at the time of the shot.
And I think Dr. DeMaio's response was it has to be leaning over because it has to be pulled away 2 to 4 inches. And then Mr. De La Rionda then said to him, well, could it be such that he was trying to back away and George Zimmerman grabbed his shirt with one hand and then shot him? And Dr. DeMaio's response was that would by nature pull these shirts towards one side. Then if you shot and released the shirts, the holes wouldn't match up anymore. So I think Dr. DeMaio specifically countered the suggestion by the state that there was pulling back with a holding onto the hand. But I don't want to re-argue his testimony, but that's what I would call it to be. To answer your question, and why it might be substantive evidence as opposed to just being demonstrative evidence, I would suggest that the absolute minimum is certainly a demonstrative tool to be used by me to present the evidence just like I can get up there and draw something myself. I think that's, not to presume too much from the court, but I think that's a given, that I could be able to use evidence and demonstrative evidence like this in a closing argument. But whether or not it gets into this substantive evidence is, as I said before, what it has taken is a distillation of known facts, and all those facts may be contested. He could contest that it is a left-hand shot. That's fine. That doesn't mean that the presentation, just like we can contest any expert, they could have brought in their animation expert. They could have brought in Dr. Rao and did to say it may have happened some other way. Let's not forget, Dr. Rao's animation, had she had one, would have been 1, 2, 3, 4, right? That's what her animation would have been. Specifically contested by our suggestion as to what happened, but her testimony was her presentation.
But that doesn't go back to the jury room to be played over and over again. That's what I'm grappling with. The difference being that whatever the witnesses testify to, and there's an instruction to the jury about the believability of the witnesses, they can believe some, all, or none of their testimony. And they discuss that. But to have an animation that goes back to the jury room that they can play over and over and over again, like they can the 911 call, that they can the reenactment and those other things, gives a certain weight to something that this court is not particularly certain that comports with the evidence presented at the trial.
I understand the court's concern. I do think that it's a proper distillation of certain pieces of evidence that in and of themselves are unassailed by contradictory testimony.
Do you have any case law to provide me?
No, Your Honor. I rely on Pierce, and I will cite back to the court some of the portions of the case law presented by the state just to say that once you determine that it is in fact substantially similar, and that's the only determination that needs to be made as far as the admissibility of the evidence, that it is substantially similar to the evidence that has been presented, then it is admissible. And that's about 2 of the cases. Valente is one of the ones.
Well, both sides are basically agreeing that Pierce is the only case in the state of Florida that relates to computer animation. Is that correct?
I did, I think, provide one other one, which is General Motors versus Porritt, Porritt. I will agree that Pierce is the only criminal case.
Okay, and does the defense agree with that?
Yes, ma'am.
All right, so when I look at the Pierce case, they proffered the computer animation as demonstrative exhibit to help Detective Babcock explain his opinion to the jury and also as substantive evidence. And the trial court ruled that the computer animation would be admissible as a demonstrative exhibit only, and made the particular findings that it did in that case. They cited to trying to look for the citation of this quote in here. It may be People versus McHugh. I'm not sure, but it says, when the results are useful, they should be accepted. When confusing, they should be rejected. And that the presentation be relevant, that it fairly and accurately reflect the oral testimony offered, and that it be an aid to the jury's understanding of the issue. Okay. Any other cases? I'm going to read your cases. There are no other cases by the defense. I understand both arguments. I need to go back here and read it. You're smiling because I've cut you off so many times. Go ahead.
I promise I'm not going to take you along with this, Judge.
All right, because we have another issue we have to address.
I know. I just want to make a couple points. Number one, Mr. Shoemaker didn't even mention Dr. Rao. He didn't use her at all. Number two, there's an underlying assumption by the defense here that the nose injury arose from the very first punch, which is depicted there in the animation, but they also claim there were many others landed that could equally have done this, so it didn't have to be the left hand at all. Number two, you can't compare this to, Madam Clerk, could I have that timeline? Because the timeline actually was every bit of it, the phone numbers as well as the times, testified to directly by a witness here in the courtroom, and the underlying data, that is the phone records, the numbers, and the connect and disconnect times, are likewise also in evidence for the jury. None of the underlying data upon which Mr. Shoemaker relies here are actually physically in evidence before this jury, other than perhaps Ms. Lauer's 911 call. The map of the crime scene isn't what he's testifying about. It's the movement of the figures about within it. None of that is underlying data that is in evidence. Number three, as far as the pullback versus verticality, I just want to recap Dr. DeMaio's testimony in respect as it relates to whether or not the victim could have been in a different position pulling back when he was shot. Dr. DeMaio actually absolutely testified that was possible. Mr. O'Mara's distinction came when he was asked whether the witness, the victim and the shooter could have been actually both standing up vertical when it happened. It is then that he said, well, I think if that was the case, you'd have to be pulling that hoodie. Of course, the hoodie is very baggy in and of itself, but those were the two things. Number three, the Pierce case makes pretty clear. In that case, Detective Babcock, who is the witness that prepared the animation and was testifying about it, would be the equivalent of Dr. DeMaio in this case. It was necessary for that detective to explain his interpretation of how he believed this occurred. That's not Dr. Shoemaker. I want to make that crystal clear. If there was any witness who could use this as a demonstrative exhibit, it was Dr. DeMaio, and he didn't need it. And finally, just the Porritt case, because the conditions of the test in this case were not shown to be substantially similar to those during the actual rollover, the videotape evidence was inadmissible. The closing remark of that, the court cannot use discretion to decide that despite a plain lack of substantial similarity in conditions, nevertheless admit the evidence. So I think the Pierce case makes clear that this has to be accurate, not exact, but accurate. What we're talking about is Mr. Shoemaker's assumptions, not only all not in the record, but he is talking about statements made out of court by an expert to him over the phone, police report information, testimony or statements from witnesses who have not testified, a la Mr. Weinberg, and those sorts of things. All of that is built into that animation. He said that he didn't just base it on actual courtroom testimony because he hasn't heard a word. Hasn't heard a word. Everything Mr. Shoemaker's got, this isn't to discredit him, but it's to point out the frailty of this exhibit, has been filtered through the arguments of counsel.
I didn't.
I think that's a signal to me, Your Honor.
No, I didn't
you.
touch it. The lights automatically go off at a certain time in the courthouse. Is there a way that we could get them back on in the courtroom? If I touch. Okay, we're back on. Okay, so you're finished with your argument. All right, I'm going to reserve ruling on this, and I'll let you know when we reconvene at 8 o'clock in the morning. The next issue is Mr. Connor, the proffering of his testimony. Could you please tell me what is it that Mr. Connor is going to testify to in a few short words? Because if he's going to testify to, you're seeking to have him testify to what was found on Trayvon Martin's phone. I can just look at what it is that you're seeking to have introduced without having his testimony proffered and make that decision. Is that what he's going to be called for? Is that he was able to obtain certain information, either text messages, videos, or pictures off of Trayvon Martin's phone?
That's correct.
Okay,
That's
can
Mr.
I please
Glass.
see what it is that you're intending to introduce through him? And I don't need to hear his proffered testimony.
Your Honor, I believe there needs to be a proffer of his testimony.
No, there needs to be a proffer of what you're seeking to introduce by way of pictures through him. I don't need to go through.
In order to explain it to the court so that the substance is clear, it's necessary for Mr. Connor to talk about how and where he found the information on the phone.
All I need to know is that he found information on the phone. That doesn't go to whether or not that information is admissible. His testimony of what procedure he did to find something on the phone is not the relevant factor for what you're trying to do. What you're trying to do is introduce certain either photos, emails, or text messages. That's what I need to look at. So can I please see what it is that you would be seeking to introduce by way of evidence through Mr. Connor?
Yes, I can outline that, yes.
Well, I'd like to
And-
see what it is. You have it there in your hand.
Yes, Judge.
Okay.
I do. I have several pieces of information that were obtained in different ways from Mr. Martin's phone. As the court is aware, this issue is actually ongoing because of the way the discovery has gone in this case. We got a report from the state on June 4th, and we're still trying to process that. But from information that we were provided in discovery sometime in late February, Mr. Connor was able to do some of the extracting. So there are two main issues. One relates to several conversations by Mr. Martin attempting to acquire a firearm.
These are conversations that are audio conversations, or are they written?
They are text messages
Okay.
that were obtained from his phone, but that's a secondary issue. We'll have a separate exhibit.
Well, no, it's not secondary because that's an authentication issue. If it is his if it's his voice, then that may not be an authentication issue. If it's a text message, it is an authentication issue.
Yes, and I need Mr. Connor to talk about authentication, but to cut to the chase, if you will, on the crux of the matters that relate to the fighting issue. That is the crux of this proffer. It's Mr. Martin's text messages about being in a fight, about the effects of that fight on him, that he got into a fight, that he lost the first round, won the second and third round, bloodied the guy's nose, wasn't done with him yet. A confirmatory text message with another friend, Michael French, confirming that he was in the fight and explaining that he, meaning the opponent, got more hits in the first round because he had me on the ground and I couldn't do anything. A Facebook post from Mr. Martin's half-brother, Demetrius Martin, asking Trayvon Martin, when you're going to teach me how to fight? And the first text message I was paraphrasing, the one is to a person named Lavandria. I have the text of that here. I have this was in a hidden file in Mr. Martin's phone that was password accessible only, in addition to the password required or swipe code to get into the phone. So this was a second level of access that was necessary. I can mark them individually or as a composite. One came from the hidden text messages that Mr. Connor found. One came from a hidden Facebook post that was in an application that was hidden. And then another from the Cellbrite extraction report from Michael French. So I would like to offer Mr. Connor's testimony to explain how he was able to access the phone and what steps were taken that would show that really, realistically, only Trayvon Martin could have created these texts or engaged in these conversations.
Okay, state.
So I'll mark these here for the court to review.
Okay, we'll mark them as composite exhibit NN for the defense, for identification. And
It's a three-part. The first one with Lavandria is the more detailed text explaining about the fight that he had just been in and the 3 rounds, etc. The other one has to do with the sort of confirmatory text message to this fellow Michael French shortly the next day. And then, of course, the separate Facebook posting by Demetrius Martin to Trayvon Martin's Facebook asking when he was going to teach him how to fight. We also can authenticate another way, if the court wants me to go ahead and proffer that as
Please.
well.
did you have some others that I have the CV of Mr. Carter marked as 00 for identification for the defense. Was N the 3 sheets that you gave me, all that you're seeking to have introduced through Mr. Connor?
Well, that's the stuff that relates specifically to the fighting. And then there are other exhibits that relate to the gun. And I'd like to, if we could, deal with the fighting issue, because that's the crux.
Okay.
That's the crux of this.
Then-
Let me assemble, I guess, the other material on the gun. That consists of, Your Honor, some pictures that were retrieved from Trayvon Martin's phone that were taken by that phone of that show a hand wrapped around a firearm, believed to be a Smith & Wesson firearm. We'll provide that. And then there are a series of conversations that occur around February 18th, just before Mr. Martin is coming to Sanford, Florida, where he has several conversations with several people attempting to acquire a firearm.
Mr. Guy, you want to address defense exhibit N for identification?
Sure. Judge Guy, I don't have a copy of it.
I can provide Mr. Guy another copy. He does have this information. In fact, we got it from him.
Judge, we do have it, but it's in volumes. I didn't know specifically what they pulled out. Judge, we're right back where we started with the motion in limine that I filed before the trial. In the Munoz and Singh case, where in an instance where two people do not know each other, specific acts are inadmissible because they don't help the jury with the reasonableness or apprehension that a defendant may feel because he has no idea who this person is. This is not reputation evidence, which otherwise might be admissible under these circumstances. Furthermore, in addition to an authentication issue, how do we know what whoever wrote this is talking about? I mean, this could be a verbal fight, this could be a play fight, this could be a slap fight. We have no idea. It would completely mislead the jury and be prejudicial. It's the kind of thing that is inadmissible for a reason. It would do nothing to aid this jury. It doesn't tell us about Trayvon Martin. It certainly doesn't tell us about what George Zimmerman knew about Trayvon Martin, and that's why the court granted, I think, this initially, is because there is no evidence that they knew each other, and therefore specific act evidence, which this is completely inadmissible. If I can just touch on the gun, if the court will allow me to, or not.
I really haven't heard the
Okay.
argument or proffer from Mr. West about that. He just mentioned that he intended to, so I'd rather you wait.
I guess in summary, my objection is it's inadmissible. It's rank speculation as to what any of this means, who sent it, what it was about. If you look carefully at these, there's no context to them. They're pulled out at certain times, and we don't know any conversation that surrounded them. It's just completely misleading, and therefore it shouldn't be allowed. And I provided the Munoz and Singh case to the court
Can I have that?
prior to trial. Singh, S-I-N-G-H. Judge, that's all I have regarding the text regarding
Okay.
finance.
Any further argument from you, Mr. West, regarding the text?
Yes, I have
Okay.
a substantial argument, Your Honor. But I want to proffer Mr. Connor's testimony if the state claims that these are out of context, because we can put them in the context in which they were on the phone.
Well, I'll allow you to proffer as long as I don't go into a long proffer about Mr. Connor's qualifications and his background and all of that. I would like to keep it just to where he found this for the purposes of the proffer. So if you can limit it to that, I will allow the proffer.
Also, we can ask Mr. Connor to testify. I do think his qualifications are important.
I have him here in a CV. For the purpose of the proffer right now, I don't. You said he got them from a place that was a second-level access. If you would like this court to understand what he means by that, I'm happy to hear that proffer. For the purposes of this proffer, I really don't need to go into his qualifications. I have his CV here. It's 00. I can read it.
Yes, ma'am.
So
The other issue I'd like to point out to the court before we do the proffer is that Mr. Guy's argument completely misses the point as to why this information is admissible. This isn't reputation evidence under Munoz. This is evidence that directly relates to the physical abilities and capabilities of the individuals at issue. That's a jury instruction that the court will give that directly relates to Mr. Martin's knowledge of fighting, that he had participated in a fight, that he knew, in fact, what it was like to be on the bottom.
well,
and not.
Mr. Connor is not going to testify as to what was intended by this, is he? Just where he found it and that he found it.
I'm suggesting that Mr. Guy's argument was misleading as to why it's admissible and the significance of it legally. So I don't want the court to think that I'm not responding to the argument because it wasn't the right one.
I'm really at the point where I want to hear the limited proffer from Mr. Connor. I'm not at the point to hear the arguments.
All right.
I understand that Mr. Guy gave an argument, but I told you I'd like to hear the limited proffer. So if we could get Mr. Connor in here, we can do that and take it a step at a time.
Right here, just put it for the.
This is a composite exhibit that relates to the gun matter, so I'll mark that as well.
All right, that will be double P.
Do you solemnly swear from the testimony presented will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Your Honor, for the purposes, could my client be outside the courtroom for 5 or 10 minutes, but continue with the proffer?
Are you waiving his appearance?
Yes, I am, Your Honor.
Okay, he may do so. Lisa here, they probably will need to use this. I'll wait until he.
There's another exhibit, it's a composite exhibit that I'll ask Mr. Connor to speak with briefly as well, that contain some photographs that were found on the phone.
Defense composite double P.
I do.
May I inquire?
This is double Q.
Yes.
No, that one,
Isn't that the one she
Double Q?
I'm sorry,
Double Q.
it is, yes, that's double Q. Good evening.
Good evening.
Please state your name for the record and spell your last name.
Richard Donald Connor, Jr., Connor.
Mr. Sorry, Judge. Oh, thank you. Mr. Connor, prior to you taking the stand, we marked a copy of your CV, and it's been admitted into evidence. Is that correct, Your Honor?
It has not.
Would I so move?
Well, this is a proffer, so if Mr. Connor were going to be testifying in front of the jury, you can move it in at that time.
In order to save time, I would like it admitted into evidence so the court can review it and consider it part of his testimony
Well,
today.
unless there's an objection from the state, I'll review it as a composite, but because when something is marked as evidence, it goes back to the jury. The court hasn't made a determination yet as to whether or not Mr. Connor is going to testify, so I don't want that as an exhibit going back to the jury.
I didn't mean to suggest that it would be admitted into evidence for the jury. It would be admitted into evidence for this proffer for
Well,
this hearing.
then it wouldn't be marked as double N. It would be marked as one for this hearing. So do you have another copy, or do you want me to take that double N?
I have another copy. I was suggesting perhaps that since the jury doesn't get things that are only marked for identification, if the court marked it as defendant's proffer 1, then we would
Well, I'll
keep
have
it
to
straight.
remark that one unless you have another one that you would like to provide. Either way, doesn't matter.
I can retrieve that one, so I have one, and substitute another.
Well, the clerk can just mark that as Defense Exhibit 1 for this proffer. I just wanted to know if that's what you wanted to do.
For that, sure. Yes.
Okay, thank you.
So, Mr. Connor, does your CV that's now in evidence for this proffer as defendants one generally describe your background and training in the area of computer forensics?
Yes.
In addition to the training specifically as a computer examiner and in forensic computer analysis, are you also a licensed attorney in the state of Florida?
Yes, I'm a member of the Florida Bar.
Have you testified as an expert in the area of computer forensics to include extraction and analysis of information from cell phones in the past?
Yes.
Are some of those instances set out in your CV?
Yes.
Are you certified by Cellbrite?
Yes, I went to their training. At the end of the training, was certified in the logical and physical.
Are you generally familiar with whatever their most recent software program is for cell phone analysis?
Yes.
And do you have a licensed copy of the current version that's available to the private sector?
Yes.
And did you use that software in whole or in part to analyze the phone that was represented to be Trayvon Martin's?
Yes.
At some point in the discovery process in this case, did you receive what's been known as a bin file?
There were several bin files, yes.
Mm-hmm. Was there a bin file that you received sometime in perhaps late February or early March that was represented to be, in effect, the data dump from the flash memory of Trayvon Martin's phone?
Yes, I believe it was February 23rd.
And did you have an opportunity to use your Cellbrite software and other software that may be available to you to begin the process of analyzing the data on Mr. Martin's phone?
Yes.
Were you able to identify text messages, Facebook posts, and such that had been deleted or otherwise hidden from a cursory examination of the phone?
Yes.
Would you describe generally what your process was insofar as the use of the Cellbrite technology?
Well, when you load the data into the Cellbrite physical analyzer software, it runs a series of scripts basically and analyzes and then parses out the data. For example, the names in the contact list, the calls in the phone call log, text messages, emails, the pictures, videos, songs and music, things of that nature. It parses them out, and I think it's called the analyzed data section of the report.
Okay. Did you, when you began this process, did you have an opportunity to look at the report, the printout, if you will, that FDLE had done in connection with this phone?
Yes.
And when you did your own analysis, did it indicate to you there may be additional information on the phone that had not been provided in report form by the state attorney's office?
Yes.
And what did you do then with the bin file, if you will, and your other resources to try to capture or identify what information that was missing from the state attorney's report?
Well, the report is only a report of what the Cellbrite reads and interprets and parses. The bin files is more like the physical image of the phone's data, so it contains all the data, all the files, all the free space and everything. So when I have the bin files and I've loaded it into the Cellbrite physical analyzer software, I can then examine any file that's from the phone, whether or not Cellbrite was able to parse it or analyze it.
Was there something that struck you when you began the process of analyzing the bin file and comparing it with the report that the state attorney's office had provided?
Yes, one of the first things that I did was in the Sellbright report that I received from the state attorney's office, for each section of the report, it lists how many items are there, how many pictures, how many videos, how many text messages, things like that. And so I looked, when I loaded it into my Sellbright, at the total numbers to see if they matched, and I noticed that one in particular, the picture number was off by about 600 pictures. I had 600 more than the FDLE report did.
Did that make you think there may be some additional information on the phone that was not part of the report?
Yes.
And what did you do in order to try to find those pictures?
I tried to figure out which pictures were different and whether they were all located in the same area or areas.
We're talking about comparing this FDLE report with what your preliminary indications were from your own software run with Sellbright.
Correct.
When you got the bin file in late February, did it include an updated report from the one that had been previously provided in Discovery without the bin file?
At some point, there was a second report, yes. It was somewhere around late February, early March, I believe.
Was it substantially different than the first one in that it contained did it contain any of those 600 photos, for example?
No.
At some point, did you later get an FDLE report that appeared to have some of the additional data that you were later able to find?
Yes.
And when was that?
I believe it was the week before this trial started, first week of June, I think.
That was the next time that report was, that was the next updated report?
Yes.
So let's talk about what you did then in order to try to identify the data that was on the phone but not part of the report that the state provided. So were you able to extract additional information by your own application or use of the Sellbright software?
Are we talking in general or still talking about pictures? Or?
Identify it however you choose. Once you realize there's more data on this phone than what was in the report, what did you do to try to find it?
I did a couple things. In terms of text, I started running some keyword searches, physical keyword searches against the bin files. I also, one of the things I do is I look through, the Sellbright report did list the databases on the phone, and I started looking through the databases to see what program or app they belonged to, what they did, and what they contained. So those are the two main things that I did.
Were you able to identify some additional photos that were not part of the report?
Yes.
Did those photos include pictures of a handgun?
Yes.
Did those pictures include a hand wrapped around the grip of the handgun?
Yes.
And when you analyzed that, were you able to determine that the pictures of the hand on the handgun were taken by that phone?
Yes.
Were they?
Yes, they were.
Do you have... I'm sorry. Mr. Connor, if I could approach, please, and show Exhibit PP. This is more than just pictures. If you would take a look at it, though, and generally describe what that exhibit consists of.
Including the text?
Yes.
There are several text message exchanges where Mr. Martin was either trying to purchase or sell a handgun. And then there are there's actually two copies of the two separate pictures, one of the handgun on a table or something, and then the other one where it's lifted off the table is in somebody's hand.
You were able to find those text messages on the phone?
Yes, they're on the phone.
And were some of them deleted?
Yes, they were, yes.
Is your software able to recover deleted text messages?
Well, they were marked as deleted, but they were still, the data was still on the phone. So each picture had a deleted version, although the data had not been overwritten, so it was still there. And there was another version that was still on the phone intact.
When someone who has a picture on the phone or a text message they don't want and they want to delete it, is that a purposeful action taken by the user of the phone?
Objection, I would call for speculation.
Sustained.
Is this something that happens by accident or as a result of the phone itself, or to delete the images and text messages? Does that require the operator of the phone to do something?
Usually, yes.
Explain if you would.
Normally, pictures, for example, will stay on the device until they're deleted or removed. Text messages, depends on the phone, but will often stay on the device until deleted or removed. That being said, devices go bad, memory cards go bad, and it technically is possible for something to get deleted without the user intending to delete it. So that's why I said it's usually user initiated.
If you were trying to determine as an expert whether this was an action by the user or a malfunction of the phone or something, would you be able to look at the text messages that were deleted within the context of others that weren't?
Yes.
And were some of these text messages deleted and scattered within other text messages that weren't?
That is correct.
As an expert, is it your opinion that these deleted messages were because of an act of the person on the phone?
Objection, calls for speculation.
Your Honor, may I?
It can be deleted by anybody. That is speculation.
Anybody, yes, perhaps, but...
But you're asking him to speculate.
No, I'm not asking him who did it yet. I'm asking him whether the text messages were deleted because of an action someone took.
Okay, well, that question would be allowed.
Yes.
Yes.
Is it your opinion that the text messages relating to the gun that show deleted were deleted by someone on purpose?
Yes.
Were you able to determine if the phone had a passcode or swipe code of some kind?
Yes.
Did it?
Yes.
What does that mean?
That means that you cannot access the data on the phone unless you input the passcode.
If you don't know the passcode, can you operate the phone?
Perhaps maybe an emergency call, but other than that, no.
Do passcodes typically time out? So that if you access the phone over a period of time, is there something in the phone that will cause it to become secure so that the passcode has to be re-entered?
Yes. For example, you may have to wait 10 minutes to try again to get in, and that time may increase each time you put in a wrong passcode.
Let's talk about what happens if you put in the right passcode and you get access to the phone. If you put the phone down and don't use it for a period of time, the phones typically have a default where they go back to the point that after several minutes or what have you, that you have to re-enter the passcode.
Yes.
Any reason to think that's not the case with this phone?
I believe there's a configuration file, and I don't recall what it said about the timeout period, but I believe it did have a default timeout period.
One would suggest, I take it, that if it didn't have some sort of timeout, that you'd only have to enter the passcode once and it would remain open forever, essentially.
Until manually locked or restarted.
Which would sort of defeat the purpose of the passcode.
That's generally correct, yes.
Is there any other information you can tell the court about that set of text messages that relate to the attempted acquisition, purchase of a firearm?
Sorry, anything else that I can?
Well, are there identifiers on these text messages, who sent them, and whether or not it was sent to Trayvon Martin or by Trayvon Martin?
Yes, the messages will state which folder they are in on the phone, for example, an inbox or a sent folder, who the other party is, whether the message is incoming or outgoing, the date and time of the message, the status of the message, whether it was read or sent, for example, the content of the message, and then the status of the message, whether it was deleted or whether it's not been deleted.
Is all of that indicated on the extraction reports you have there?
Yes.
Was there a conversation between Trayvon Martin's phone and a person identified by name and number as Ron Cuevas Fulton about purchasing a .22 revolver?
Yes.
Were these conversations concerning the acquisition of a firearm clustered in date?
Yes.
When was that, please?
Yeah, just the ones with Qua Fulton, or all the ones that we have here?
All of the ones that you have regarding what seems to be the acquisition of a firearm.
Between February 18th of 2012 and February 22nd, 2012.
And how many separate collections of text messages do you have there on that?
Several. There's 1, 2, 3, 4. I think there's at least 4.
With different people?
Yes.
Can you identify who those people are from the information on the phone?
Yes.
Who are they, please?
One is Qua Fulton. That's one. There's another group that there's two other people involved in addition to Mr. Martin, but I think they run together as one kind of conversation. That's the other parties are Spoonhead Zach and Jay. And then there's another set of conversations that with another person named Ron. There's conversations with a person named Dario, and another conversations not about purchasing but about a gun with Diamond. And I think that's it.
Did you...
Fruit. I don't think I mentioned fruit.
Fruit?
There's a conversation with fruit also.
This collection of conversations were all between February 18th, 2012 and February 22nd, 2012?
Yes.
Were there some text messages on the phone where Trayvon Martin was talking about coming to Sanford?
Yes.
Are you generally familiar as when he was planning to come to Sanford from reviewing those text messages?
Yes.
Tell us, please.
I believe it was February 20th to 21st, around that.
And you know enough about this case that he was killed on February 26th.
Correct.
Let me show you another exhibit. This one is marked Defendant's QQ for the proffer. Let me ask you if this is based upon information retrieved from the phones.
Yes, it is.
What is it?
This is a picture that appears to be of Trayvon Martin that was resided on his cell phone.
Does it appear to be a self-taken picture?
Yes, it does appear to be that.
Was that picture taken with that same phone that you analyzed?
That I'm not sure. There's no metadata in the image that identifies the device the picture was taken with.
What is metadata?
Best description I've heard is it's data about data. So, for example, in a picture, very often if you take a picture with pretty much any digital camera or cell phone these days, within the picture file itself will be data about the picture, the make and model of the phone or camera, maybe the focal length, the date and time, maybe GPS coordinates, all kinds of data about the picture itself. That's metadata.
are you able from that metadata to learn more about the circumstances and the device where the picture was taken?
When it exists, yes, it often provides additional detail for us.
You said this photo appears to be Trayvon Martin. Is that based upon other photos that you know exist that depict Trayvon Martin that you've seen either on the phone or online or on TV?
Yes.
Were you also able to extract a series of text messages and other postings that appeared to relate to Mr. Martin having been in at least one fight?
Yes.
Let's talk about how you were able to recover the data on the phone that related to that extraction.
There was data on the phone in a database that was not parsed or analyzed by the Cellbrite software. And so when I went and manually looked at the database, I saw that it contained what appeared to be text messages. And then when I looked at the database and the configuration file associated with the database, the database appeared to be created by an Android app called Super Android SPC, I think. And when I researched that, I saw that it was an application that was designed in part to hide text messages. And basically what it did was text messages that were subject to this application were not put into the main text message database that you think of when you look at an Android phone. It was placed into another database that was only accessible to this Super Android application. For that reason, I believe it was not parsed or analyzed by Cellbrite, but when I went and looked at it, I could see the data was there, it was in plain text, and I could extract it and analyze it.
How did that get your attention? What made you think there's more here even than what running Cellbrite had revealed to you about the missing pictures and such?
There were a couple things, and I don't remember the exact order or which one was the final tipping point, but one of the things I was doing was running keyword searches, and I was getting hits of what looked like text messages, but they were not in the parsed text messages in the Cellbrite report. That was one indication. Another indication was the SPC database was listed in the databases, but there was no parsed data from it in the report. And then I know I'm missing, there's one other indication. But I think those were the two primary ones, the search results, and then when I eventually got to look at it, I could see that it contained what appeared to be text messages.
Is that something that you were piecing together, realizing that there was more on the phone than what was indicated in the report from FDLE that provided by the State Attorney's Office?
Yes, and I think you need to keep in mind when I originally got this data, there were certain things I had been asked to look at. So there were other things that I noticed that I was kind of noting in my mind and putting on the back burner until I got to them, and this was one of them. And
thinking that there might be something else going on, you mentioned a hidden app. Were you generally familiar with the existence of those sorts of things?
Yes, I knew that those type of apps existed.
And what did you do in order to find the hidden app on this phone and then get access to the information that had been previously hidden?
Probably ought to describe what I mean by hidden. When we're using the term hidden, it's hidden from the user of the phone, unless you know the app and the code. So if you wanted to see these hidden text messages, if you were holding the phone in your hand, you would have to pull up the app, and it had a passcode, and you have to put in the passcode, and then you could view these text messages. So they're hidden from the user of the phone unless you know how to get to them. Once I get the phone, they're not exactly hidden. They're not parsed by Cellbrite, but they're not hidden either. Once I locate the database and I access the database and view the database, I can see the data in plain text. So it's not parsed by Cellbrite, but then again, it's not hidden by the application from me either.
Are you saying that there is a passcode necessary to unlock the phone so the phone can be used, and then a second passcode that would have to be entered into this application to access these text messages?
That is correct.
So in order to get access to the text messages, arguably you'd have to know both passcodes.
Objection to leading, speculation, and argument.
Sustained.
May I have a little leeway with an expert to lead so we just stay on track, Your Honor? I will rephrase it, though. How many passcodes would it take to get access to these hidden text messages if someone handed you the phone?
At least 2.
Would that be the access code necessary to open the phone up for any purpose?
Yes, you'd first, if the phone was locked, you'd have to put in the passcode to unlock the phone. Then you'd have to locate the app that was hiding the text messages and put in the password for that app. And then you would get access to the text messages.
How would, if you were unfamiliar with the phone, how would you know what app that was?
You would not know. You'd have to try to find and maybe see if you got lucky finding the app, and then you'd still have to enter the password.
So for someone else to use the phone, they would have to figure out the first passcode in some way.
The phone passcode, yes.
And then they would have to figure out that there was another hidden app on the phone that had text messages.
Correct.
And then figure out what the passcode was to access that application.
Yes.
And then at that point, would they be able to send and receive texts?
Yes, they would be able to see the texts that were being hidden by that application and probably respond to those text messages.
Well, I suppose if someone had gotten through those levels of security, they could, you said they could respond to the messages or delete messages or something, but...
Yes, they would basically have the access that the user who set up the application, the password, would have.
When you were looking at the context of the text messages, in the regular texting and also in these hidden files, did you consider whether it appeared that someone else was using this phone to send text messages and delete messages other than Trayvon Martin?
That's always something that we look for and keep in the back of our mind. At least I do. So yes, that is something that I took into consideration as I was examining the data.
Were the text messages that you've extracted relating to the gun and fighting, which we will talk about, contained within a larger conversation with the same person typically?
Yes.
And did those conversations appear to indicate a relationship between that person and Trayvon Martin?
Yes.
I'm losing track of my thinking here, but were you able to collect the various text messages from whatever source related to firearms and assemble them in the exhibit before you?
Yes, that is what I did.
Let's move to another exhibit. This one's been marked for identification in this proffer as NN. If I could approach the witness.
Yes, ma'am.
Are you familiar with that exhibit?
Yes.
And what is it, basically?
It's a composite of data relating to fights or fighting.
Did all of that data come from Trayvon Martin's phone?
Yes.
And did you extract it in some fashion or another?
Yes.
You mentioned earlier that there was a database that was accessible through the hidden app as opposed to through Cellbrite.
Again, there's accessing it by the user or accessing it by me. If the user's trying to access the data, they have to go through the special app and the special password. Cellbrite, from my point of view, Cellbrite does not parse or analyze the data, but it is there, and I can manually access it and view it using the Cellbrite software.
Looking at the first page of Exhibit NN, I think is the one before you.
Yes.
The header at the top has an identifier as spc.db log sorted by person.xlsx. Could you explain that, please?
Yes. I created this spreadsheet, and it comes off of the phone, and the database is the spc.db database. That's what it's named on the phone. A database, in this case it's a SQLite database, and a database consists of several tables. So for example, in this is the log table as named by the application, and it's a log of the text messages. There are several other tables. One, for example, may be the contact or name table. It'll have the names of the persons that he was texting with or in the address book, their phone number, etc. So, and this is presented to me in the Cellbrite software in a table, and I can then use the Cellbrite software to export it basically into a spreadsheet, which is what I did. And my software named it by beginning with the name of the database on the phone, spc.db, the table in the database, this is the log table, and then appending the Excel extension to the name of the file.
From a longer conversation in this thread with the person Lavandria, were you able to extract a conversation relating to a fight?
Yes, there were other messages going back and forth between Mr. Martin and Lavandria, and I extracted these specifically because they did relate to a fight.
And does your spreadsheet show the phone number of Lavandria?
Yes.
And you know this to be from Trayvon Martin's phone?
Yes.
And are you able to tell from the spreadsheet and your analysis which of the two sent and which of the two received the messages?
Yes.
Are you also able to identify the date and time that these messages were sent?
Yes.
What is the first line in your exhibit of text?
The number or the content?
I have a larger extraction here. So what's the first line of text on your exhibit?
WYD question mark, which is what you doing?
You recognize that to be text code or slang for what you doing?
Yes.
And who sent that?
Lavandria sent that.
And did Trayvon Martin respond?
Yes.
What did he say?
Tired and sore.
Did Lavandria respond to that?
Yes.
What did she say?
Me too, but what happened to you?
I'm going to ask Mr. Connor that you do the best you can to pronounce the way it's actually written.
That's what I was attempting to do.
Okay. So when Lavandria said, me too, but what happened to you, what did Trayvon Martin say?
Fight.
And what did Lavandria say after that?
Letter Y, exclamation, question mark.
And what did Trayvon Martin say to her?
'Cause man, that nigga snitched on me.
And what did she say to him?
Bay, why you always fighting? Man, you got suspended.
And what did Trayvon Martin say in response?
Nah, we thumped after school in a ducked off spot.
And what did Lavandria say?
Oh, well, damn me.
And what did Trayvon Martin say in response to Lavandria?
I lost the first round, and it's got the kind of a happy face, I guess the colon and the parentheses. But I won the second and third.
And then did he repeat that with a different smiley face, the frown as opposed to the smile?
Yeah, it's basically the same, but it's I lost the first, but won the second and third.
And did Lavandria respond?
Yes. Oh, so it was 3 rounds with a question mark. Dammy, well, at least you won, LOL, but you need a... Actually, there's another couple words on that.
Can you read that whole line?
Yes.
I can show you my copy.
I've got a copy also.
Okay.
But you need to stop fighting, Bay, for real.
And did Trayvon Martin respond to Lavandria?
Yes.
What did he say?
Nah, I'm not done with fool. He gonna have to see me again.
Did Lavandria respond?
Yes.
And what did she say?
No, Bay, stop. You ain't gonna be satisfied till you get suspended again, huh? With a question mark.
And what did Trayvon Martin say?
Nah, but he ain't breed enough for me. Only his nose. But after that, I'm done.
The text that you read said breed.
Yes, but he ain't breed enough for me.
If that were a typo and it were an L instead, how would it?
Objection, speculation. If
I have to sustain as to speculation.
Have you seen typos before in text messages that you reviewed as part of your phone analysis?
My analysis in reading this is that the word breed does not make sense and is not what was intended.
What would make sense?
Bleed.
With an L, bleed.
With an L, bleed.
Judge, I'll renew my remark or my objection as to speculation. Ask for that
Sustained.
remark. Ask it be stricken.
Your Honor, I would not want the record stricken. This is a proffer. This is, unless the court hasn't ruled. Did the court rule on Mr.
Ruled on
Mann?
his objection to speculation. It is what it is. What's written there is written there. What the person intended or not, he cannot testify to. What he believes may make sense may not make sense to the author of it. So that's just speculation on his part. My ruling stands.
Have you, in your training and experience and work analyzing phones, computers and phones, have you had occasion to try to make sense out of text messages or computer messages that weren't grammatically or accurate from a spelling standpoint?
Objection, relevant.
Overruled as to relevance.
Yes.
In the context of this text message sequence, as you try to sort out the data on the phone and make sense of the conversation, does the word breed as opposed to bleed make sense?
I think when you put it in the context of the rest of that message, referring to not enough and only his nose, yes, I think they're talking about bleeding from the nose.
Thank you. If you would...
As to speculation.
Were you able to, by analyzing the data on Mr. Martin's phone, find another conversation around that time that seemed to reference that fight?
Yes.
And to whom was that text message?
Michael Suave French.
And do you know that person from information on the phone? Did you have his contact information and other conversations between Mr. French and Mr. Martin?
Yes.
And what is the conversation that Mr. French and Mr. Martin had connected with this fight?
Mr. Martin sent a message to Mr. French stating, yeah, because he got more hits in Yeah, because he got more hits because in the first round he had me on the ground and I couldn't do nothing. And then Mr. French responded, dang, bro.
Is that the end of that sequence?
Yes.
Did you also find a reference to fighting by a relative of Trayvon Martin?
Yes.
Who is that person?
Demetrius Martin.
And what did where was that information located or posted?
It was on the phone. It was in a Facebook database. I believe the name of the database is FB for Facebook.db. Inside the database, as in the other SBC database, there are different tables. One of the tables in this database is called mailbox threads. And this particular message was in the mailbox threads table of the Facebook database on the phone.
And what did the message on this Facebook mailbox thread say?
It was from Demetrius Martin, and it said, "When are you going to teach me how to fight?"
Do you know from other information Demetrius Martin's relationship to Trayvon Martin?
I believe there's some kind of brother, half-brother related with the same, sharing the same father.
What makes you think that?
Because there's one other message in the Facebook database in the mailbox thread table from Demetrius to Trayvon, asking Trayvon if Dad had a Facebook page.
You believe, based upon the context of these conversations, that Demetrius Martin was talking to Trayvon Martin about their common parent?
Yes.
Were there other references to fighting or questions? Were there other discussions in the context of your review of the text messages where people discussed fighting to some degree?
Yes.
You didn't extract those for this exhibit because you couldn't find them directly related to this event? Is it, or
Correct. Or because I could not put it in the date, time, or who sent them, yes.
Your Honor, I would move the marked exhibits into evidence for the purpose of the proffer, please.
We'll have to take them out of where they've been marked in the case. So NN will now come in as defendants 2 to this proffer. PP will come in as defendants 3, and QQ will come in as defendants 4 to this proffer.
In summary, Mr. Connor, sort of identifying the different places on the phone where you found information to direct the court as to what the overall scope of your work was that's reflected in some of these reports. There was some information in the report that FDLE filed initially that you were able to verify within the bin file?
Yes.
And then there was additional information in the bin file that you were later able to extract that was not contained in any FDLE report that you received prior to about June 4th.
Correct.
And there was information in this bin file that you were able to extract from applications that were hidden on the phone?
I'm going to object to leading and already asked an answer.
The jury's not here. It's fine. Go ahead.
Is that accurate?
Yes,
And to do that, to get the access to the hidden application, you had to download some software, figure out what it was all about, and review what was otherwise not visible on the Cellbrite reports?
no, no, it was not parsed or analyzed by Cellbrite. So I had to manually identify that it was on the phone and then manually go access the file or the data and look at it. The Cellbrite did not present it for me. I had to manually go find it and look at it and analyze it.
And
Which I did.
some of that report is reflected in some of the pages of the exhibits before you,
Correct.
as well as some information that may have been extracted through the Cellbrite software itself.
Correct.
And then photographs that you were able to extract from the bin files.
Yes.
That would include the picture of Mr. Martin, the sort of profile picture.
Yes.
And the pictures of the handgun with the hand that we talked about.
Yes.
I don't remember if I asked you this. Were the pictures of the handgun with the hand taken by Mr. Martin's phone?
Yes, they were taken by the phone.
Cross?
Connor, sir, when did you notify defense counsel that you had found some additional information that you didn't believe anybody else had found, or at least anybody else had reported?
I'm sure it was soon after I found it.
So February-ish?
Late February, early March, yes.
And as far as the phone itself, are you aware of whose name that phone was actually in?
I believe it was, yes, I've seen the paperwork. I think it was the mother's, maybe. I don't remember whose name it was in, but I have seen it.
It was not Trayvon Martin's, correct?
His name was not on the bill, correct, or the account.
Okay. And this was actually a phone on a family account, one of several on that account. Am I right?
I believe that's correct.
Okay. And can you tell me, you referenced this discussion over a gun. You said it was between two people and either one or both of them was either trying to buy or sell a gun?
No, there were the different conversations I identified, there were 4, 5, or 6 different ones. In each of them, well, in most of them, Mr. Martin was looking to purchase a gun. In one, there was a discussion about a gun, somebody else's gun, and in the last one, somebody was trying to buy one from Mr. Martin.
Okay. And this was a .22?
There were discussions about several different calibers.
Okay. Obviously, none of which he had on his person the night he was shot and killed by George Zimmerman.
That's what I've heard.
Okay. We know what caliber that was, right?
I don't. I'm sure you guys do.
All right. As far as this, these discussions about fights or fighting, in any of them let me just ask it this way. In any of these discussions, can you tell me who was operating the keyboard at the time the message was sent, the keypad?
Let me answer it this way. Number one, I was not there when the messages were typed. However, when you view 8,000, 9,000 text messages on a phone, you get a flavor, you get the cadence of the people, and so you get I think I can get a pretty good idea of whether it's the same person or not.
Is that a long way of saying you would like to think so, but no, you can't tell me for sure?
Again, I was not there when the messages were typed, but would they all appear to be by the same person?
Or when the photos were taken, right?
I was not there, correct.
And in fact, as to the photo, what we've called the profile photo, it looks like you have that on the exhibit there as 3 separate dates, 11:15, 11:30, and 2:10.
No, that's the date. That's the data from the phone. It's on there 3 times.
Okay, but it's the same picture,
Yes,
all apparently originally created on 11/15 of 2011.
probably yes.
Okay, so we're not talking about 3 different pictures, 3 different profiles. It's the same picture, just repeated a couple times.
Correct. They have the same hash values, which means it's the same picture.
Okay. And that, of course, the profile picture has nothing to do with hands or guns or any of that being visible. It's simply basically just a torso and face shot of Trayvon Martin, right?
Correct.
Okay. And it's not posted in connection with either fights or guns, right?
Posted in terms of text messages?
Right.
Correct.
As far as this deletion, deletion can be accomplished by anybody who had access to the phone and knew the app and how it worked, right?
And the codes to get to it, yes.
So as we've discussed, you weren't there to tell me who, if anyone, actually did any of that as it relates to Trayvon Martin's phone.
I was not there when.
When were the deletions accomplished? Were they done all in mass, or were they done little by little?
I cannot tell that.
Can't tell that.
No.
So, just asking you a hypothetical as an expert,
Mm-hmm.
if a person, parent or sibling or whoever, had discovered stuff in a phone and deleted it, you couldn't tell me whether that was done like that time all at once, or whether, for example, if we assume that the daily user of this phone was Trayvon Martin, he deleted things as he went along. Can't tell me which one of those that might have been.
I can give you my opinion.
Okay, based on, I thought you just told me you couldn't tell.
No, there's nothing in the data that tells me when a particular deleted text was deleted.
Okay.
But as you look at it, you can see that certain ones are deleted, certain ones are not deleted,
Sure.
and you can look for patterns. So
But as to when that got done, you can't tell me.
that is correct.
Certainly as to by whom, you can't exactly tell me, although
Well,
I understand you have a suspicion.
I
get
was
that.
I was not there when the texts were deleted.
As far as the material in the phone, any reason to suspect that George Zimmerman knew anything about any of it on February 26, 2012?
I don't know what George Zimmerman.
Certainly no communications to anybody
I
called
saw
George Zimmerman.
no text to Mr. Zimmerman.
Thank you, Judge.
Any redirect?
This idea of this mass deletion of text messages, where the text messages deleted seem to relate to certain subjects.
Certain subjects or certain people. It seems that text messages to and from certain people were deleted. Other ones were not.
Text messages about drugs and drug use that were deleted.
Yes.
Some of the text messages about the guns, trying to get a gun or sell a gun, that were deleted.
Yes.
Is there anything that would indicate to you that someone other than Trayvon Martin got a hold of this phone and deleted a bunch of these messages all at once?
No.
Were there images of pornography on the phone
Yes.
that were not deleted?
Yes.
Well beyond the scope of the offer.
Same.
Your Honor, this directly relates to Mr. Mantai's claim that someone else could have deleted these text messages. I submit that if some family member got a hold of this phone, they wouldn't have gotten rid of the talk about fighting and guns and left all the pornography on it. I think that the court needs to know what else was on the phone that rebuts what Mr. Mantai is suggesting.
Again, that has nothing to do with the scope of the proffer, which was only as to these exhibits.
Okay, it has nothing to do with the scope of the proffer. I understand your point. Go ahead.
Could you explain that, please?
Well, yes. There are the pictures of the gun were hidden also on the phone, and by a separate application that was on there. And what this application did not put them on the SIM card where pictures normally go, but it created a folder basically in a program file with a French language name, so it looked like it was a French language folder. And it put the pictures in that folder, and it also renamed the extension. The pictures taken with the camera are JPEG pictures, and they have a JPEG, JPG extension. What this app did was it also changed the extension of the pictures from JPEG to .bin. So in normal computer and digital data use, if, for example, you go to click on a bin file, your app's going to tell you, I don't know what this is, I can't open it. Whereas if you double click on a JPEG, it'll open up as a picture. So this app moved them and hid them, and again was password protected. And these were pictures that were not deleted off the phone. Whoever was using the phone would have to, again, have the codes to get to those items and know where they were.
Are you saying it's a separate hidden application from the one for the text messages?
Yes.
So there were two hidden applications that required a separate access?
Yes.
And the text messages were in one of them, and the pictures of the gun, among others, were in another?
Yes.
And that, if I hear what you're saying, the casual user of that phone wouldn't see those pictures unless they knew how to access that application?
Exactly.
And the application assigned a different file name so it would not appear to be a picture?
Correct. If you were just browsing the content of the phone, if say you had an app so you could browse the folders and files, you would see these as bin files and not as picture files.
Thank you.
Thank you. May Mr. Connor be excused? Can I have the exhibit?
You may.
Thank you. May Mr. Connor be excused?
Yes, Your Honor.
Thank you very
Thank you.
much, sir. You may be excused. Okay, the testimony's been proffered. I'll hear argument.
Your Honor, there's some additional evidence offered. As the court is aware, Rachel Gentile has been a witness in this trial, and that she also was deposed. She was deposed over a period of 2 days, a little over a month apart, and of course the state was present. And at her deposition in April of this year, while she had denied that Mr. Martin had talked with her about fighting, that in the deposition in April, she did then acknowledge that she'd had a conversation with Trayvon Martin where he told her that he was in a fight. And in fact, he told her that he knew how to fight and that he was in a fight that he won. We know from her testimony in trial that she'd only renewed her acquaintance with him after a number of years, in February 1st. So these conversations about fighting, knowing how to fight, having been in a fight that he won, took place within the couple of weeks prior to Mr. Martin traveling to Sanford. So that sort of closes the loop, if you will, on this authentication issue that I anticipate the state will argue. So we can offer the pages of the transcript, or the court can accept my proffer of the questions.
I'm sorry, I don't understand. Is it your proffer for the purposes of this proffer of Mr. Connor's testimony, or is it another proffer of something you want introduced in the trial in front of the jury?
Your Honor, the larger issue is whether Mr. Connor will be allowed to testify as to the content of these text messages on Mr. Martin's phone. The court has already raised the question of authentication.
I just want what you just told me about the proffer of Ms. Gentile's deposition. Is it for the purposes of this hearing or for the purposes of the trial?
No, for this.
Okay, thank you.
excerpt of the deposition that I can just mark as an exhibit that references what I just orally proffered about that deposition.
I'm not saying I'm objecting, I'd just like to see which I took first. I have to make sure we're in context, please.
Mr. Manti, I'll substitute one that's not marked for the exhibit, but you're welcome to review that.
Are we ready for argument?
Judge, I'm fine with the court accepting whichever.
Okay, that'll come in for this. Purposes of this hearing is defendant's exhibit number 5.
Number 5 will be the transcript.
Yes.
And did we review
I have the
exhibit?
other exhibits here. I have, although they haven't been remarked by Lisa, but I'll give them to her in a moment. I'm ready for argument.
All right.
If you want to mark these and then give them back to me. Thank you.
Before I forget, Judge, Mr. Zimmerman has a 10 o'clock curfew. May we have it extended until a reasonable time after
Yeah,
court?
it'll be extended for 30 minutes after court is concluded.
Is that enough? Thank you, Judge. Okay. So on the argument part of this, we are asking that Mr. Connor be allowed to testify as to the substance of the text messages that he recovered from Trayvon Martin's phone, specifically as to the fighting. I think that's the core issue here. We laid the predicate for a picture, if it's otherwise relevant and we want to offer it, and for the pictures of the gun and the discussions about the gun. I'm not ready tonight to make the argument why the pictures of the gun and the discussions about the gun
I don't have the
are-
pictures of the gun. Defendant's exhibit number 4 has 3 pictures of the profile of Mr. Martin.
There is an exhibit that was marked that has the discussion of the gun.
Right,
And,
I have that, but I don't have included in defendant's exhibit number 4. The first page is an extraction report with numbers 1, 2, and 3, and then it has 3 pictures of the same picture. Those are the only parts of this exhibit. I don't have a picture of a gun.
Does the court have the exhibit that has the text messages referencing the gun?
Exhibit number 3 is an extraction report. Oh, yes, here it is. Well, let's see if the pictures are attached. There's an extraction report that has 4 thumbnails. Oh, here they are. They're attached to that, yes.
Yes, okay. And that has the gun and the handle on the gun?
Yes.
Okay. So I don't want to address that specifically tonight. The hour is late, and I'm not suggesting that Mr. Connor can, at this point, come before the jury and testify about the gun and the hand on the gun and the text messages, because I don't think that's been directly related, at least not yet, to the facts of the case. That would go more toward a notion of aggressiveness, maybe even a fact supporting a violent tendency. And
What part of the evidence code are you seeking to have this introduced? This information? All of the information that was proffered by Mr. Connor?
I believe that it most squarely is admissible under, well, no, it's different depending on what parts of the exhibit. The picture of Mr. Martin is simply that he has laid the predicate for a picture of Mr. Martin. That's not related specifically to fighting or guns. It's just a picture of Mr. Martin that was on his phone that shows his physique. That's the relevance of that. The pictures of the gun, the hand on the gun, the discussion of buying a gun and such is not directly related to the fighting issue. The fighting issue, the central core of the presentation, two legal grounds. One is 90.803. That's an exception to the hearsay, prohibition against hearsay that does not require the declarant, that the availability of the declarant is immaterial, and that it relates to an then existing mental, emotional, or physical condition. And in that primary text message with Lavandria, Mr. Martin is asked how he's doing, and he says he's tired and sore. And that's because he had just been in a fight that he had won, a fight.
What part of, I understand that, but I'm just trying to find out now, what part of the evidence code are you seeking to have that evidence admitted?
90.803.
All of them are 9803?
The text messages regarding fighting, I'm seeking under 90.803, and also under the legal authority of Chambers versus Mississippi, but that's a separate argument. I'm not addressing the admissibility yet of the firearm pictures because I don't think that we've connected that up completely with the evidence before the jury. So I'd like to concentrate on the evidence of fighting and why that's admissible under several theories. Not as reputation testimony under Munoz and such, but under 90.803 as reflecting a then existing mental, emotional, or physical condition. And that mental or emotional physical condition was at the time that Mr. Martin was in the fight, that he won the fight, and that he explained how he won the fight. He won the fight by, while losing the first round because his opponent was on top of him and rendered him helpless, much like the testimony was that he rendered George Zimmerman helpless in this case.
Okay, can I interrupt you for just a minute?
Mm-hmm.
So you're seeking it under 9803 sub 3?
Uh-huh.
Okay, go ahead.
That's one of the legal grounds. That he talks about having been involved in, obviously, an orchestrated fight that was orchestrated for 3 rounds, that he lost the first round because his opponent was able essentially to take him to the ground and make him helpless by being on top. He also talks about how he won the second and third rounds and therefore actually won the fight. He also talked about how he was able to hit the person in the nose and make their nose bleed, but he wasn't satisfied that there was quite enough blood, so he talks about how he's not done yet with this guy. And of course, he's cautioned by this person that he should quit doing this stuff. That conversation about that particular orchestrated fight is corroborated by the conversation with Michael French that occurs within a few hours while he talks to Mr. French about this event having gone 3 rounds. So we know those are connected in time and in content. Certainly helping toward the authentication that those were the words of Trayvon Martin to 2 people that he communicated with regularly. Mr. Connor talked about how there were conversations with these folks on other subjects and that he extracted just that part of it that related to the fights. There's also a Facebook post by Trayvon Martin's younger half-brother, Demetrius Martin. And we can offer evidence in the record to connect up all the dots on that. Mr. Martin has several children. One of them, 2 or 3 years younger than Trayvon Martin, is Demetrius Martin. He identified all of that at his deposition. So we have more of the loop being closed that Demetrius Martin asked Trayvon Martin when he was going to teach him how to fight. Obviously, Demetrius Martin thought that Trayvon Martin knew how to fight enough that he would ask for his advice and training. We also know from the evidence, the proffer of the deposition of Rachel Gentile, that within the first couple of weeks of February that Trayvon Martin told her that he had been in a fight, that he had in fact won the fight. And we know that from Rachel Gentile, who obviously knows Trayvon Martin's voice and knows him personally, and testified that it was Trayvon Martin that told her about being in a fight that he had won. All of that is strong circumstantial evidence, if not clear direct evidence, that all of these conversations were by Trayvon Martin, his words being sent to his friends about a fight that he was proud he had won because he was able to draw blood from the man's nose and to ultimately prevail, even though he'd been in a difficult situation in the first round. So factually, we've connected the dots on authenticating this. Why is it relevant before the jury? Because, as the court will instruct the jury, the relative physical abilities and capabilities of the parties is relevant. There's a jury instruction that says just that. And this jury is going to be asked to decide who George Zimmerman was physically, what his physical capabilities were, as well as Trayvon Martin's physical capabilities. And that includes knowledge. That includes experience. That includes Trayvon Martin's experience in fights, having been put in a position of vulnerability by being put on the ground. However, of course, in that fight, it was an orchestrated 3-round fight. So when Trayvon Martin lost the first round, when he couldn't get up, whoever was refereeing it stopped it. And then they had 2 more rounds, which Trayvon Martin was able, by hitting this fellow in the face, apparently take steps toward winning. So that shows clear knowledge of Trayvon Martin prior to his contact with George Zimmerman, that he'd been in a fight, that he knew how to fight, and that he, in fact, knew what George Zimmerman would experience when he was on top of him, because the similar thing had happened to him in the past. We know that this is relevant because the state took great efforts to try to make that information relevant as to George Zimmerman. If the court will recall the testimony of physician's assistant Lynn Folgate, one of the things that the state took great pains to get this court to agree to and ultimately to question Ms. Folgate on was when Mr. Zimmerman spoke with her about his exercise regimen, that he had mentioned to her that he exercised aerobically with MMA. And the state made a big deal of that. They made a big deal about it in the case, that he had experience as MMA based upon the medical records from the Altamont family physicians, I guess it is. So we know these things are relevant because the state wants it to be relevant in their case. It's likewise relevant in our case because the jury is going to have to make that decision. So because I think that this information shows the existence of Mr. Martin's mental state shortly after this event occurred, because he's telling Lavondria that he's tired, that he's sore, that he had just been in a fight that he had won, that it is in fact admissible under 90.803.3, the existing mental, emotional, or physical condition at the time of the event. I'm not suggesting that that statement was him talking about anything in February of 2012, but it does in fact, on a relevant matter, show his thinking and his emotional and physical condition at that time. this is clearly compelling evidence in support of Mr. Zimmerman's self-defense claim. The testimony is that Mr. Martin sucker punched him, was able to by surprise, frankly, and then shortly thereafter was able to get him on the ground where he was mounted. We know from the testimony that mounting is when you straddle somebody around the area of the hips, and that it is an extremely vulnerable position because there are very limited acts that one can do, unless they are very skilled, to get out from under it. You are essentially helpless, and you are subject to the whims of the person on top. We know John Good said he saw Trayvon Martin mounted on George Zimmerman MMA style, and that we know from the physical evidence in the case, all of the physical evidence, frankly, especially the testimony related to firearms, corroborates that the shot was fired from the ground up, that the shirt was separated from the skin by somewhere between 2 and 4 inches, and that it exactly corroborates and is consistent with not just what Mr. Zimmerman said, but with what John Good observed some 10, 15, 20 seconds earlier when he went outside to investigate. So this is absolutely compelling evidence and is highly relevant and admissible under 90.803. We submit that it's also relevant because not to admit it in this case under these circumstances would violate Article 1, Sections 9 and 16 of the Florida Constitution and the 5th, 6th, and 14th Amendments of the United States Constitution that guarantees an accused to confront the witnesses and to present evidence in support of their defense, guarantees due process of law in presenting a defense. This theory, this constitutional principle of, if you will, preservation of the accused rights is discussed in the United States Supreme Court case of Chambers versus Mississippi. The court, I anticipate, is familiar with that decision, but what's to be taken from that decision is that a state's hearsay rules and such cannot be mechanistically applied to deny an accused the right to mount a defense. So I suggest that any application of a rule of exclusion because the court finds it to be hearsay or any other reason would be instead a mechanistic application of that rule that the Constitution of both the United States and Florida prohibits, especially under circumstances where it's clear that the evidence is reliable and trustworthy. We have closed the loop on all of this. It was Trayvon Martin's phone. It was Trayvon Martin's words in the context of all of the other words through the thousands and thousands of text messages that he had with others and with these individuals. He talked about a specific incident where he talked about his skill and the other person's skill in fighting, that he was able to injure the person, but he wasn't done with him yet. Completely consistent with what happened on February 26th when George Zimmerman was screaming for help, but Trayvon Martin wasn't done with him yet and kept on going and kept on going. We have indeed closed the loop the rest of the way with Rachel Gentel's deposition testimony, that within a couple of weeks of this event occurring, Trayvon Martin had been talking with Rachel Gentel about winning a fight, being in a fight, knowing how to fight. So this isn't something that the state can say isn't authenticated, isn't reliable, could have been somebody, anybody else just typing this stuff out. That's not at all credible. That can't possibly be the case now that you've heard the testimony of Richard Connor about these text messages, the context of these text messages, and of course what we've said here today about the highly probative value of this very, very relevant evidence. The default of this court should be to allow Mr. Zimmerman to present a defense, to guarantee his constitutional rights to present a defense. And this evidence is one step in that process. So we urge the court to allow Mr. Connor to testify about these text messages.
Thank you. Response?
But I think Mr. West has just made my point. He's got an orchestrated fight with a referee. He's telling us how many rounds there are. He's telling us that somebody's mounted another person and then they got off the ground. That's not in here. I mean, that's exactly why this type of evidence should not be before a jury. It is rank speculation. He's told a story that is not in these messages on Trayvon Martin's phone. We don't know, again, what type of fight he's talking about. If it's a slap fight, a play fight, a verbal fight, a wrestling fight, we don't know what it is. We don't know if the word fight is code for something else. We don't know anything about if there was a fight between Trayvon Martin and someone else. We don't know who his opponent was. Was he fighting Andre the Giant that he could lose a round to and then beat in a couple other rounds? Or was he fighting a little girl? I mean, that's why this sort of thing should not be admitted. That doesn't even address the authenticity issue. I mean, he keeps saying we've tied all the, connected all the dots. I submit to you he hasn't. We don't know who typed these messages. We don't know if they're connected. He said the message with Lavondra and to the other gentleman was hours apart. Actually, they were the next day. The message to, or the conversation with Rachel Gentile was weeks later, if not months later. Again, there's an authenticity issue, and they keep talking about the then existing mental state. We don't know when this fight was. There's no indication with any definitiveness as to when these fights took place. So,
I'm sorry to interrupt, except as a point of procedure. Mr. Manti did the cross, and now Mr. Guy is doing the argument. Are we allowed to do that here?
Well, Judge, that's the way we designed it. It's my issue. I filed the motion in limine. Mr. Connor was Mr. Manti's witness. So that's why we found it this way. That was his witness and my issue.
Okay, go ahead.
This was the issue I argued before the court. Judge, so again, we've got an authenticity issue. We've got whether or not it was then existing mental state. Again, there's no definitiveness as to when these events occurred. But most importantly, we don't know exactly what was meant by these words. Are they code for something else? And again, the danger is exactly what Mr. West has put before the court, that there's an orchestrated fight, that there's a referee, that there's mounting going on, none of which is in here. There's talk about being on the ground. That's it. It is not competent evidence. If there's any probative value, it's outweighed by the prejudicial effect of what a jury might imagine was meant by those text messages that may have been sent by Trayvon Martin and may have been about a fight. Your Honor, I don't know if the court wants me to address the issue of the photograph. I think it's Exhibit 4 or the information purportedly about a firearm.
The firearm, Mr. West said he wanted to address at a later time, so you don't have to address that.
Your Honor, the photograph appears to be Trayvon Martin, but they said they offered it for, I can't remember the term he used, but the best photograph of Trayvon Martin for this jury to consider is the one of him on the medical examiner's table that was taken just shortly after his death. We don't know if when this photograph was taken. We don't know if it was something that he took right after he worked out and got all pumped up and maybe took a picture of himself for that reason. We just don't know. But the best photograph are the ones already in evidence that were taken at or about the time of his death. So for that reason, I see no probative value to the photograph, as we already have that in evidence. If I can just have a moment. And Judge, they relied on Chambers versus Mississippi, again, I don't think the purpose of that is to eradicate the evidence code and to allow into evidence items that are subject to the type of speculation and misinterpretation that this proposed evidence is. So I would ask the court to continue to grant the state's motion and deny this evidence. Thank you.
Thank you. Any further argument?
Only brief response as to the authentication issue specifically. Well, first of all, as to the content of the text messages, they are what they are. I'm not suggesting that we should be allowed to explain them when they're offered to the jury. The jury will see them and give them whatever weight they choose to give them based upon what they believe them to mean. As to the authentication issue, this issue is mired in the mess that discovery on this issue has become. There is a pending motion for sanctions before this court that will be taken up at the end of the trial because Mr. Della Rionda stood before this court and said, we gave the defense everything. We offered the testimony of Wesley White, we offered the testimony of Ben Credos, that in fact wasn't true. And we finally got the report from Mr. Brenton at FDLE on June 4th. June 4th, and we still haven't had a chance to go through it because we had the Fry hearing, we've had 2 weeks of jury selection, and what is this, our 3rd week of trial? I can't even keep track of time. There is an ongoing discovery issue, violations. In fact, Mr. Guy stood there silently when Bernie Della Rionda said, we gave him everything, there's no other report. We didn't get any information from anybody different than what we gave them. And we know that's just not true. Mr. O'Mara said to this court, let's relax some of the authentication issues, if nothing else, because we can't get through this issue with the timetable the court has set. There is no authentication issue. In fact, the authentication issue that Mr. Guy raises is illusory. And to the extent this court thinks there is one, it's because of the state's misconduct, not because of anything that we've done.
Even if you were to take everything out of that bin file, it would still be the same issue. It's coming from the same phone.
We did not have the ability.
Well,
we were misled, Judge. We were given a.
Go ahead.
We were given a report at the same time we were given the bin file in late February. The report was misleading. It did not contain the same information that the state had in its possession at that time. We got the report, which was incomplete.
Mr. Conner testified that he found 600 additional photos that the state didn't know about. So
that's not true. That's just not true.
I thought I heard him say that. I'm sorry.
That's what he said, but that's not true that the state didn't know about them. We had testimony before this court from Ben Credos that he printed 2 reports. We're getting off on a really
side issue because my point being is, if you had 5 years to look at that bin file, it's still coming from this same phone.
We
correct?
Only wanted an
it's
extra week.
It's still coming from this same phone, correct? Yes.
The data set is the data set, yes.
Okay. It's still coming from this phone. The information that you're seeking now to introduce through Mr. Conner, I do have an authentication issue about it. 90.901 is the requirement for authentication or identification. 90.901A, 901.1A, and I'm reading from Earhart. The most common method to authenticate the electronic record or message is by the testimony of a person with knowledge who created the record or message of that printout accurately reflects the contents that the witness created or sent. And it goes on and it brings you to footnote number 3, and it references Griffin versus State, 419 Maryland, 343, 19, A, 3rd, 415, 2011. And State versus Ellick, E-L-E-C-K, 130 Connecticut Appeals, 632, 23, A, 3rd, 818, 2011 case. An electronic document, example, email, text messaging, and networking sites like Facebook, may continue to be authenticated by traditional means such as the direct testimony of the purported author or circumstantial evidence of distinctive characteristics in the document that identify the author. Typically, electronic messages do have self-identifying features. For example, email messages are marked with the sender's email address, text messages are marked with the sender's cell phone number, and Facebook messages are marked with a username and profile picture. Nonetheless, given that such messages could be generated by a third party under the guise of the named sender, opinions from other jurisdictions have not equated evidence of these account usernames or numbers with self-authentication. They cite another case of Commonwealth versus Purdy, 459 Massachusetts, 442, 945 Northeast 2nd at 372, 2011 case. Evidence that electronic communication originates from email or social networking website that bears purported author's name is not sufficient alone to authenticate it. Another case, they cite emails authenticated not only by defendant's email address, but also by inclusion of factual details known to the defendant that were corroborated by telephone conversations. And my point being is that what has been presented to the court, Exhibit 2, Exhibit 4 is the profile picture. Exhibit 2 and Exhibit 3 has nothing identifying Mr. Martin. He doesn't say, hey, this is Trayvon, or it has going out to Lavandria, coming back in from Lavandria. It has the phone numbers, it has the time, but anybody could have picked up that phone and sent these text messages. A third party could have access to it. People have children who pick up their phones and play with them and send text messages to their friends or other people. I don't have any identifying marks that these text messages are created by or sent by Mr. Martin. I have a concern about that.
Well, we know the phone had a double level of security. We know that.
And I know any 7-year-old can learn the passwords and get into that because they do it all the time.
FDLE couldn't do it for a year almost.
Well,
They sent this phone all over the country, and they had to write code for it.
but a person may know that password. Another person may know that password. FDLE didn't know the password.
It's evident under 90.901 that there's evidence sufficient to support a finding that it is what we claim it to be. All of this came off of Trayvon Martin's phone. There are thousands of pictures, thousands of text messages, no indication that anybody else was using his phone. Mr. Connor looked at all of those text messages. Further, under the authority of is it Manuel?
Yeah, it's on the same page.
Manuel v. State, is that the one you're talking about? 357 Southwest 3rd, that one?
Yes.
Cited in Earhart's book, I guess, Mr. O'Mara pointed this out to me to suggest, I don't know what else we could do under these circumstances when the state didn't give us the information timely.
But even if the state gave you that information, is my point. What on these text messages identify that they were created by Mr.
We
Martin?
would have had the time and the opportunity to find the witnesses on the other end, first of all. And we have not had that because of the state withholding valuable, exculpatory, probative evidence in this case repeatedly, and then misrepresenting to the court what they did. And then finally, when we caught them doing it, we get it on June 4th. Judge, I don't know what else we could have done, frankly. We asked for time. We wanted to depose Steve Brenton. We asked the court to delay the case a few days. I don't know what else we could have conceivably have done under the circumstances to further this authentication issue under the circumstances that the state is solely responsible for. It's simply unfair for Mr. Zimmerman not to be able to put on his defense because of the state's tactics. It was a strategy, obviously, because they had it in January and kept it from us, made us spend 10, 20, 30, 100 hours digging it out, playing games with us, lying to this court, and now it's our fault. It's our fault. To deny Mr. Zimmerman the right to present this information violates both the Florida and the United States Constitution. Thank you.
Does the state want to respond?
Judge, not in substance, but because Mr. West said, I would offer him the opportunity right now to apologize to me for suggesting that I stood by silently with information that I did not have.
I'm not getting into this. Court is in recess. I will give my ruling in the morning. I'll see you at 8 o'clock in the morning. Court is in recess. It is
It's 10 o'clock at night.
9:56. No, court is in recess. Thank you very much. With all due respect, we'll see you at 8 in the morning. Well, at 8 in the morning, the issue is Mr. Donnelly, who may have violated, or counsel has informed the court that you know that he violated the rule of sequestration. That's the second time today that I've heard that there's been a violation of the rule of sequestration by the witnesses. I don't want to take that up at 9 o'clock and have the jury sit out there and wait like they did today. We will be in recess until 8 in the morning. And so have I.
Not being able to prepare or get my witnesses gathered for tomorrow, and I can't do it tonight.
I'll see you at 8
Judge,
in
I'm
the
not
morning.
physically able to keep up this pace much longer. It's 10 o'clock at night. We started this morning. We've had full days every day. Weekends, depositions at night.